Ice. I got here around 7 o'clock. I always worry about parking and stuff, so I get here way too early. No, just pacing out. I don't. Each individual stays where I stay at the Cabot Lodge up on North Monroe. Where's that? It's the Cabot Lodge. It's a little bit crummy, but it serves its purpose. I wouldn't enjoy a nice place anyway. Do you have to belong to the 11th Circuit to argue up there, or you do? They make you jump through a lot of hoops to join, right? Or to get, no? Oh, okay. CLE.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save the United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on the court's calendar today is Pasha versus State. Mr. Bolatin.
May it please the court, I'm Steve Bolatin from the Public Defender's Office in Bartow. I represent the appellant Khalid Ali Pasha. Mr. Pasha stands convicted of 2 counts of first-degree murder, and he's never had his day in court. He had a day in court, in fact, about a week in court, but he has never had his day in court. I'll tell you at the outset, Mr. Pasha is not the most easygoing or malleable individual Faretta defendants never are. He's prideful, articulate, a bit stubborn, mistrustful. His courtroom demeanor has been appropriate and courteous. Mr. Pasha basically has the temperament of a lawyer. In this case, a rift developed between Mr. Pasha and his guilt-phase attorney, Nick Sonardi. The rift began as a matter of trial strategy, but actually it goes beyond trial strategy, and it became a personal distrust issue as well. What happened here is Mr. Sonardi concluded, and I don't think for purposes of this appeal it matters if he was right or wrong, whether his analysis of the case was on target or not, but he decided that the only way he could try this case was to concede Mr. Pasha's guilt of second-degree murder and try to avoid a death sentence. Mr. Pasha emphatically protested that, did not want to do that. Mr. Pasha wanted to maintain his innocence, wanted to put the state to its proof.
Before you're starting appropriately with what happened in the final discussion of whether Sonardi was going to be discharged, do we, in analyzing anything about Faretta, look to the history in this case that he began with a public defender, and he had private attorneys, Gonzalez and Hernandez. Then there was 2 years where he did represent himself, and then then he obtained a lawyer after he had frustration with not getting records, and then he had Sonardi and Fraser for that period. Does that factor in any part of our analysis as to whether the judge ruled correctly?
Yeah, I think it factors in. I don't think it's dispositive. Where that comes into play, yeah, there is some history here, and I need to discuss it in a little more depth in some of the things I pointed out in the reply brief having to do with what the state represented. But because if there had been no history here at all, then it would be irrelevant what Mr. Pasha's reasons were for his dissatisfaction with Mr. Sonardi. He could have had no reason at all. He could say, I don't like this. I don't like the way this guy combs his hair. I want to do it myself. I don't like him, and that would have been fine. Because there is a history here, I think it becomes relevant to show, okay, the state is claiming that Mr. Pasha's request was was insincere, manipulative for purposes of delay. In view of that being their contention, I think it's appropriate then to look to whether or not Mr. Pasha had good faith reasons for his request. And he clearly did, having to do specifically with Mr. Sonardi and not having to do with the past history. Now, I do want to discuss one thing on the past history that I think is important. The state makes the claim in its brief that every time that consistently on the eve of trial, Mr. Pasha would change his mind, and therefore his requests were manipulative and insincere, and that's just simply not true. What occurred here, yeah, Mr. Pasha is a classic Faretta defendant. Mr. Pasha likes to do things his own way. But once he was representing himself and had gotten Gonzalez was standby counsel, and Gonzalez and Hernandez had been removed, and Mr. Pasha was representing himself, and consistently the pretrial judges, the pretrial divisions, Judge Timmerman, Judge Tharp, would lecture him. I mean, Mr. Pasha was upset because he felt like that the jail's rules were arbitrary and selectively enforced in terms of his having access to his discovery materials. He had 4 and then later 5 boxes of discovery materials. He was only getting 1 box at a time. Well, on the one hand, I can tell you, if I had to write this brief and I only had 1/5 of the record to work with at any given time and didn't have access to the third part until I got rid of the first part, I'd have a problem too. But yes, that's what you get when you're in jail and you're representing yourself. And the judge wasn't wrong to tell him, I'm not going to tell the jail how to run their jail. It's a security issue. This is something you're going to have to deal with because you're representing yourself. And I believe at least 5 or 6 times during the pretrial proceedings, judges chastised Mr. Pasha for this is all your fault. It's your fault you can't get access to materials because of your bonehead insistence on representing yourself. That's why you're having all these problems. Well, the case was, there's one time during the pretrial proceedings that a trial was imminent. The case was transferred to a trial division, Judge Padgett. Case was going to go to trial. Mr. Pasha still had the problems with access to his materials, but he was ready to go to trial. And they're going back and forth, and Judge Padgett is saying this is never going to get any better with this access to materials thing. I'm going to set the trial. It's going to go. And then he updates the Feretta inquiry with him once again. Are you sure? Are you sure you don't want to request a lawyer? Things would be much better for you here if you had a lawyer. Are you sure you want to represent yourself and go to trial next week? And Mr. Pasha says, I want to represent myself. He was invited to change his mind on the eve of trial, and he didn't do it. He said, I'm going to represent myself. What happened was, this is on a Monday. The trial was going to begin on the following Monday. On, I believe it was Friday, the parties are in court, and the state has discovered that a piece of evidence that it always had, a surveillance tape from the Aetna building, which they had thought was worthless, that there was nothing on the tape that would be of any use. The previous day, the police officers were up at the FDLU in Orlando reviewing this surveillance tape again, and they found, lo and behold, hey, there's something in here we think maybe we can use. There's something that maybe shows something here, and Mr. Pasha hasn't seen it yet, and we obviously can't go to trial yet. So, and the judge agrees, well, you can't go to trial yet because of this, and the state's saying this is going to be important to our case, although it turned out it was very trivial. But that's why Judge Padgett basically says, okay, I'm going to return this case to Judge Timmerman, and whenever this is ready for trial again someday, you can send it back to me. Well, when he came back for trial, it went to Judge Fuente for trial the following year. But the period of time when Mr. Pasha requested counsel was 3 months after that, in November of 2006, when they were going on about some photographs that were at issue, and Mr. Pasha said something about, well, I can get together with the state attorney and we can look at the negatives. And the judge says, how are you going to do that? Were you going to hold it up to a light? And Mr. Pasha says, well, there's a machine you can look through. And the judge says, well, you don't have access to that. If you had a lawyer, he'd have access to that. You should have a lawyer. Then you could, and at this point, when trial is not imminent, Mr. Pasha relents. This is the fifth or the sixth time he's been chastised for his insistence on going to trial pro se. Finally, this time he says, okay, fine, I want a lawyer. He's still making it clear, I want a lawyer who will work for me, but yeah, I want a lawyer. So now the judge switches gears. He's been chastising him for insisting on representing himself. Now he chastises him for changing his mind, which he's been invited to do repeatedly.
That's not what happened. I mean, look at the transcript. Okay. You have elected to represent yourself, but I want a lawyer. Are you changing your mind now, sir? You want counsel to represent you. I've always wanted counsel to represent me. I never wanted to be pro se. I'm pro se because I'm forced to be pro se. That's what he said.
Oh, okay, at which point are we talking about now?
This is on the hearing on November 29th, 2006.
Okay.
The one you're talking about.
Right. Okay.
Now he's saying, no, I've always wanted a lawyer.
Well,
this is after he's had after he's had a number of Feretta inquiries. And he's always been maintained, I want to represent myself. Suddenly he's saying, I've always wanted a lawyer. How is that not game playing?
What he means by that is I want a lawyer, but these lawyers I get don't do what I want them to do, and given that I've got these lawyers, I want to represent myself. He's not being inconsistent. This was the same position he took at the time of the Nelson hearing and the Feretta hearing at trial. Yeah, it's great to have a lawyer. I'd love to have a lawyer, but not this guy. And the problem he's got with Mr. Sonardi is very specific to Mr. Sonardi, and it really doesn't play into anything that's gone before. I don't know what his reasons were for having a problem with the public defenders or Brian Gonzalez, but the problem he had with Mr. Sonardi is that Mr. Sonardi basically said, I am going to concede his guilt of second-degree murder. I'm going to, in effect, plead him guilty without not only without any assurances of voluntariness, but where it's over his protest.
So what was his problem with Mr. Gonzalez?
I don't know.
On the November 29th hearing, he said, I want a lawyer, but I don't want Mr. Gonzalez representing me. So Sonardi's not good. Gonzalez is not good. What was the problem with Gonzalez?
I don't actually know what the problem with Gonzalez was, other than he wasn't satisfied with him. He wasn't doing what he wanted him to do on discovery or whatever. There's no indication that any of the prior people had told him that they were going to to concede the guilt of second-degree murder. I can't tell you specifically what his problem with Gonzalez was. It's probably fair to say, from what I can see of Mr. Pasha, it's probably fair to say that there aren't many lawyers he wouldn't have had a problem with. I can give you that. But let
me ask you something else about when someone is representing themselves. Is it the trial judge's obligation at every point, every hearing, whatever, to offer the defendant counsel again? Because you seem to be taking issue with the fact that the trial judges would tell him that, look, this would go a lot smoother for you if you had a lawyer. Are you sure you want to represent yourself? Isn't that the trial judge's obligation at every stage of these kinds of proceedings?
Okay, yes it is, and I'm not taking issue with their doing that. I'm just saying that he wasn't willy-nilly changing his mind to delay things. He was doing the very thing that people were telling him he ought to do. And I'm not saying it was inappropriate of the judges to renew it. Now, there are cases where if a judge has renewed the offer, like pretrial at like 7 or 8 or 10 different hearings, he may not be required to do it at the 11th or the 12th. At some point, it becomes understood that the client knows it, although clearly you have to renew it, certainly at the trial or at the penalty phase. But what I'm saying here is that when the one time when push came to shove, the case was going to go to trial, and Judge Padgett says, I'm not continuing this case. This is going to trial. Do you want, things would go better for you if you had a lawyer. Do you want a lawyer? Mr. Pasha said, no, I want to represent myself. And he was about to do that. And then the state came up with not even a new piece of evidence, but a change in their perception of the piece of evidence. And that's what caused that particular delay. Now, what I'm trying to say is, I'm not saying that this case didn't take longer to come to trial than it would have if you'd had a client who'd just said, I'll let my lawyer handle everything. I understand that that's true. But the question is, was his request made specifically with regard to Mr. Sonardi prior to this trial? Was that done? Can the state show that that was done for purposes of delay or for purposes to game the system? And if...
Well, isn't it the case that there's certainly no finding by the trial court to indicate that it was done for such a purpose? And furthermore, there are statements by the trial court that indicate that the defendant here had behaved himself and had been courteous and had otherwise conducted himself in a way that the trial court could not fault.
That's correct. And what happened here, the initial Ferretti hearing, which was absolutely, it was before trial. Let me go through the sequence here a little bit because I think this is important. He requested a Nelson hearing. He requested initially to remove Sonardi, and they had a Nelson hearing, and he did not prevail at the Nelson hearing, and I'm not saying he should have prevailed at the Nelson hearing. At the end of the Nelson hearing, he starts very clearly invoking his right to self-representation, in effect saying, okay, Judge, you won't remove Sonardi, therefore I don't want Sonardi, I'll represent myself. And the judge says, that's not before me now, do a written motion, and I promise you I will hear it before trial. And he was as good as his word. He heard it before trial. They had a Ferretti hearing. Prior to the Ferretti hearing, Mr. Sonardi stated on the record in the hearing of Mr. Pasha that, number one, I can't represent him the way he wants to be represented. I can't make a reasonable doubt argument. I can't argue for his innocence. I don't think anybody could. I cannot represent him that way effectively. He says, he's basically saying I cannot put the state to its proof and argue that they didn't prove him guilty of murder effectively. Hearing that gives Mr. Pasha, without even anything more, it gives him a good faith reason to say, okay, fine, I'll do it myself. But in addition to that, Mr. Sonardi starts arguing case law, and what he's doing is he's extending the case law way beyond where it goes. He's arguing the Nixon case and the Harvey case, and he's basically, Nixon and Harvey say that where a lawyer concedes guilt of a charged crime or lesser, and the record doesn't clearly show a waiver or consent or anything like that, that they're not going to presume ineffectiveness of counsel per se from that, that the question of ineffectiveness of counsel will still be determined under the Strickland v. Washington standard. What he's extending that to a situation of where the client basically says before trial, I don't want you to do this. I emphatically do not want you to concede that I'm guilty of second-degree murder. I didn't kill these people. I'm innocent. I want you to put the state to its proof. I want you to argue my innocence. Mr. Sonardi was saying Nixon and Harvey give him the right to do what he intends to do over Mr. Pasha's objection. The judge was pretty skeptical of that. The judge made a number of comments saying, I don't think you can do that. I think it would require consent. And Sonardi argues with him and says, I think Nixon and Harvey let me do this. They go back and forth on it, but both before and after the Ferretti inquiry, Sonardi states his intention to concede Mr. Pasha's guilt of second-degree murder. Ultimately, he backed off. I suppose he backed off because of the judge's statements questioning whether or not he could do that, but the judge keeps saying, I can't tell you how to try your case, but. Okay, so now sandwiched in between Mr. Sonardi's statements that he's going to concede guilt of second-degree murder and he can't represent Mr. Pasha effectively by arguing for his innocence. Sandwiched between that is the Ferretti inquiry. The Ferretti inquiry begins with, are you absolutely certain that you want to proceed? I understand this motion to mean that you do not want to be represented by Mr. Sonardi. Are you absolutely certain that you want to represent yourself? And Mr. Pasha says yes. Then they go through a textbook Ferretti inquiry, and Mr. Pasha passes it with flying colors.
Which inquiry is that? What day?
That would be, I believe, October
22nd.
I think the 22nd may have been the Nelson hearing. The Ferretti hearing was 2 days before trial. It was like 5 days after the Nelson hearing. I'll check it here. Date of the...
Is this after a written motion was filed?
Yes.
The day that jury selection was going to begin?
I believe it was the morning that jury selection was going to begin.
Okay, so he filed a written motion to proceed pro se, and then...
He filed the written motion as he was directed to do by the trial judge, who said, I promise you I will hear it before trial. File a written motion.
October 22nd, 2007.
What date?
October 22nd, 2007.
Okay.
The day jury selection was to begin.
Heard before trial. Appellant, following the court's instruction, filed a written motion to proceed pro se, which was, as promised, heard before trial on October 22nd.
That's when Sonardi brought out the disagreement on the trial strategy.
Well, no, that was brought out also at the Nelson hearing. It was discussed at the Nelson hearing and the Ferretti hearing.
So let me ask you. I mean, what is your position? That your client is entitled to choice of counsel, and if I don't get the lawyer I want, then I want to go pro se.
Absolutely, he's not. He's absolutely not entitled to choice of counsel. He's entitled because he did not meet his burden on the Nelson inquiry. If he had if the judge had agreed that there was ineffective assistance, then we'd be talking a different issue. But because he did not meet his burden on the Nelson issue, then he gets the Nelson ultimatum. This court has called it the Nelson ultimatum, which is you got to make up your mind. I'm not going to remove your lawyer. I'm not going to replace your lawyer. Do you want to go with this lawyer, or do you want to represent yourself? And Mr. Pasha made his choice abundantly clear that given that choice that you have given me, given that choice that's the only choice available to me under the law, I do not want Sonardi. I will represent myself. He couldn't have been clearer about it, and he never backtracked from it in any way.
But the judge decided that the request was equivocal.
The judge decided that the request on October 22nd was equivocal based on his answers at the end of the Ferretti inquiry part.
Now, in our standard of review of that, here's this judge. Which was this? Which
this
judge?
was Fuente.
Had he had prior experience with this defendant?
A little bit, not a tremendous.
I guess what I'm asking is this is it a legal, factual, mixed question of law and fact that we see the cold record, and he's filed his motion to proceed pro se, but in looking at the history, is there a basis in the record for the judge to find that the request was in fact not unequivocal?
Well, I don't
but
believe...
what's our standard in looking at it?
I believe the standard here is de novo. I think it's a pure legal question. I mean, you can see what his answers were, and you can determine legally whether that was equivocal or not.
He stated, I would love to have a lawyer. Definitely, I'd rather have a lawyer. Okay, but apparently I don't have that choice.
He's responding to the Nelson ultimatum.
That
what he's saying, I'm sorry, what he's saying is, Mr. Pasha's intelligence and candor actually hurts him here. What he's saying is, in an ideal world, of course I'd rather have a lawyer. I'd rather have Perry Mason, Johnny Cochran, Roy Black. But I got Nick Sonardi, and I don't like him. I don't like the way he's trying my case. Look at this court's body of law in Ferretta. Virtually every case you've got is like that. You don't get I must say Buell versus Cooksey for that proposition. You don't get a guy comes up there, unless he's crazy, unless he's a megalomaniac, you don't get a guy who says, I always wanted to be a lawyer. I really think it'll be fun to represent myself. I'd rather represent myself than have any lawyer in the Western world. You don't get that. What you get is, I don't like this guy that the state has appointed for me. If I'm stuck with him, if I'm stuck the way he's insisting on doing this trial, I'd rather do it myself. That's what Mr. Pasha absolutely did. And look at the fact, look at Ferretta itself. Ferretta talks all the time about that the right to counsel doesn't mean the state has a right to impose compulsory counsel against a defendant against his will, and paternalistically say, well, we think you're better off with this guy even though you don't.
Well,
it's talking about a problem with the specific lawyer.
There is an important underlying issue about the overlay of Nixon, because, and I am concerned about that, and I'd like, hopefully Mr. Brown will address this. Do you believe that under Nixon and the progeny, that even if, again, the defendant unequivocally stated, I don't want this strategy, that the lawyer would be able to pursue the strategy that he thought was best for the lawyer? You think that's not what Nixon
That's
says.
not what Nixon and Harvey say. It goes way too far.
Judge would say, so the options that would have been faced is that Mr. Sonardi would either say, listen, I can't follow this strategy, so I would have to withdraw from representation. I mean, that would be, because if he doesn't feel he could pursue this defense in good faith, and how can he represent this lawyer, this client? He
could have done that, and that might have been better. That would have solved Mr. Pasha's problem.
But what about if he appoints another counsel, and the next counsel has the same problem?
That would have been a good reason. That's why I think the judge was probably right in refusing to appoint another counsel.
So what is the problem here?
The problem is that Mr. Pasha should have been able to do it himself.
Even if the strategy, what you're saying is, because that strategy, even if it's unreasonable, then it's the defendant's strategy.
And that's Ferretta. Just read Ferretta, and Ferretta says that a whole lot better than I could ever say it. But what I'm saying here is that, you're talking about Nixon and Harvey, all right? We know, for example, that the strategy of a trial is for the counsel, and the objectives of representation are for the client. Well, here we're talking about the objectives of representation. A lawyer can't tell you, I'm going to do my job, I'm going to walk out of here and go home. And Ferretta talks about, the consequences of a conviction are on the defendant. The lawyer can't say to the guy, I'm going to do this the way I'll feel good about myself professionally, and I'll try to get you off a death sentence, and I'll go home and I'll be feeling pretty good. And the fact that you're 64 and you're going to be doing anything other than acquittal, as a practical matter to Mr. Pasha, meant you are going to be spending the rest of your life in prison. From Mr. Pasha's vantage point, it was entirely reasonable to say, I don't want what you're trying to get from me. I don't want the objective that you're trying to get.
Well, and the fact of the matter is, it doesn't have to be reasonable.
Right, exactly. It doesn't.
And objectively, given the evidence here, it might not have been reasonable. But that's kind of beside the point when it comes to the Ferretta right. He's an autonomous individual. And if he wants to represent himself and he can meet the test, then he's off to the races representing himself under our Constitution.
Absolutely true. It doesn't have to be reasonable, but I think it's worth noting that in Mr. Pasha's case, it actually makes sense given the situation he found himself in. I'm not sure I would make the same choice. I'm 60, okay? I'm not sure I would make the same choice, and maybe I'm unreasonable. But I think a defendant has a right to say, I got one day in court, and I want to maintain my innocence. I want to put the state to its proof. As Justice Labarga said, if Mr. Sonardi had an absolute ethical problem with it to where he couldn't just couldn't ethically represent Mr. Pasha under those circumstances, he should have moved to withdraw. And then what do? Do you appoint another lawyer? Well, that would be discretionary with the judge. He could do that, but he didn't have to. He could have said, you made your bed, Mr. Pasha, you lie in it. And that's pretty much what he did say.
But again, going back to the portion of the transcript that I read to you, your client is saying, I've always wanted a lawyer.
And
I just
that's
want
what
the right one.
my client is, in a weird way, a very honest guy, and that's what he said also at the Ferretti hearing.
But he's wreaking havoc with the record here.
No, he's really not. What he's saying is entirely coherent. I mean, his statements, if you read the entire record, his statements have been consistent. It's not, in an ideal world, I want a lawyer. I like lawyers. Lawyers are good. I've worked with lawyers. Some are great, some are terrible. In an ideal world, I want a lawyer, but I don't have that choice. Under the law, under what you're telling me, Judge Puente, I don't have that choice. You have presented me with two choices, not three, not six, not infinite variety of choices in a hypothetical world. You have given me two choices. I can either have Mr. Sonardi get up there before the jury and tell them I committed this murder that I said I didn't commit, or I could do it myself. Given that, he was as unequivocal as he could be. I don't see any inconsistency in Mr. Pasha's position. I think the problem is Mr. Pasha hurt himself by responding to the judge's questions with candor.
And you're well into your rebuttal if you want to save some time.
Yeah, I will do that.
Okay,
Thank you.
Thank you. Mr. Brown.
Good morning. Scott Brown on behalf of the state. Petitioners Nelson and Ferretta maneuverings in this case had successfully delayed his trial for 5 years.
Well, let's just get right to the point here. Where in the world do you point to in the record to say that Mr. Pasha's request for counsel was equivocal?
The language that Justice Lobarja mentioned, and remember, Chief Justice Quince, we have a record here of Pasha successfully invoking his right to proceed pro se. And I would like this court to compare.
But I guess I'm really concerned with what is equivocal about a statement that says, I don't like or I don't want this lawyer to represent me. And you have already said that he's not ineffective. My only choice that's left to me is to represent myself, so that's what I want to do. What is equivocal about that? And that's in essence what Mr. Pasha said.
Well, if Mr. Pasha had left it at that, Your Honor, and remember, what we have here is the judge entertaining on the morning of trial this untimely motion to represent himself.
But wasn't it that he had said after the Nelson hearing, he said, I want to represent myself, and the judge says you need to put it in writing?
No, he didn't say that at the Nelson. 5 days prior to trial, they had a full and fair Nelson inquiry, and at no point during that hearing, 5 days prior to trial, did Mr. Pasha state equivocally or unequivocally that he wanted to represent himself.
So is your argument it's the morning of October 22nd was untimely? I think what Justice Quince was wanting to stick with, whether the request was unequivocal.
And I'll address both of those. The judge was well advised at that point, given this history, to find it untimely. But the trial judge...
But the judge didn't find it untimely.
No, Your Honor, absolutely not. What he did is he goes, okay, Mr. Pasha, that's your right. He embarked on a thorough Ferretta inquiry. Now, at the conclusion of that inquiry, when he's asked, are you sure you want to discharge Mr. Sonardi and represent yourself, he said, well, it is wiser to have a lawyer, but he did not think Sonardi put forth effort in my situation. And when asked if he wanted a lawyer but did not want Sonardi, Pasha replied, yes, sir, but I don't have that choice. So it means I have the only alternative to go pro se. At that point, the trial court said, wait a minute, I'm finding this equivocal.
But it's not... But
you forgot the next paragraph in the next statement.
Exactly, Your Honor. And this is
the next statement says, as I stated, I would love to have a lawyer, definitely. I would rather have a lawyer.
Yes, Your Honor.
That was his concluding statement.
Exactly, Your Honor. And that's the point, because the judge at this point is telling Pasha, hey, I'm finding this equivocal. You need to clarify this for me. And what does Pasha say? As I stated, I would love to have a lawyer. I would definitely rather have a lawyer. But apparently I don't have that choice. And that's when the judge said, I'm finding this equivocal. Because your statements, to me, do not
your opposition
clearly indicate.
Your opposition says this is the classic kind of statement that flows out of following a Nelson inquiry where people are upset and saying you're not doing what you should do for me. And it's his view that the law is that this is sufficient to permit the self-representation, that's an unequivocal request.
And I disagree with his interpretation.
And where's the law? What law do you rely on to take that position?
This court's decision in Hardwick v. State, when the fallback position was, I'd rather represent myself then. And this court indicated that that was equivocal. And again, the burden's on the defendant because the fallback position is always your right to counsel.
Well, how does this case differ from Weaver? It seems to me that Weaver is a case that really is pretty much on all fours factually and legally with this case. And then in that situation, when Weaver says basically, I don't want this man, so I'll represent myself, we said that's unequivocal.
I disagree, number one, with the language. When you say you love to have a lawyer, Mr. Bolatin is a very sharp appellate advocate. If we come up here and the judge had discharged Mr. Sonardi and forced Pasha to go to trial pro se, Mr. Bolatin would very easily throw these same words back at us. And again, that's the point of it. If you're going to invoke the right to represent yourself, let's be clear about it. Because the judge is placed in a difficult position on the morning of trial. And that's why it's an abuse of discretion review. Let me ask you this
question. That, first of all, I appreciate your frustration. This is not a constitutional right that is one of my favorite constitutional rights. And I think the trial judges they're faced with terrible situations with defendants like this. These are as Mr. Bolatin's conceded. This is my concern in this particular case. As Justice Kennedy said earlier, the judge did not find that this was made for purposes of delay. The guy, he said that this defendant had conducted himself in an appropriate manner in all ways, was polite. The particular dispute really goes to me to the core of why somebody might and has a right to represent himself. He adamantly disagreed with Mr. Sonardi's decision to essentially concede murder and go on a defense of lack of meditation. He goes, I am not guilty. That's the defense that I want to set forth. Mr. Sonardi, in many of these colloquies, was saying, I don't feel good faith as a lawyer that I can go that route. Now, there's a question, of course, if this goes to the next stage and we affirm and whether he's ineffective for going the route he went. But to me, that gives a classic reason for a defendant who's being foolhardy in asserting this right to say, I absolutely disagree with this strategy. I want a strategy that would give me acquittal. Any lawyer, you take 1,000 lawyers, no lawyer would say that's a reasonable strategy, but isn't that the essence of the right and why we allow Ferretta and the right to represent oneself? So to me, that puts this case, that overlay of this disagreement on the fundamental strategy that there should be self-determination, that a defendant then who wants to say, listen, I can't go with this strategy. Mr. Sonardi is not feeling comfortable going with a compromise strategy, and that would be hard to put him to that test, that under that circumstance, he should be able to represent himself. And that, to me, makes this case different from some of these others where you're going back and forth, and they're just dissatisfied with everyone. So please help me with that dilemma, which is this defendant did not want the defense that Mr. Sonardi was prepared to offer.
Well, Your Honor, really it's a continuation of his problem with every single prior counsel. Justice LaBargia, we know that the initial public defender, Mr. Littman, was discharged because he didn't sufficiently believe in Mr. Pasha's innocence. There wasn't a conflict? The public defender's office didn't have some kind of conflict in this case? No, Your Honor. He was, in fact, the initial judge in this case gave, after a full Nelson hearing, said the PDs are not being ineffective. So what you have here, and he discharged them anyway and entered Mr. Hernandez and Mr. Gonzalez. So you have a long history. And again, Justice Parrington.
Well, maybe the history, when Justice Labarga said about the colloquy on November 29th, what he said, and I made a note of this, says, I'm not going to accept no counsel if I feel a person is not working that hard. I don't care if it's Moses. I don't want, working, I don't want him if he doesn't have my interest at heart. Like I say, I've been working with politics and lawyers since I was 16, not as a victim, but working with them in their duties. Counsel is smart people. They know a lot. I've seen them put forth an effort to work and those who don't. If I have those who don't put forth an effort, I don't want them. If they put an effort, then I definitely want a lawyer. And that seems to me his theme, right? He disagreed with every lawyer because he's insisting on his innocence. Any good lawyer is saying, you can't win this way. And those lawyers, they were all certainly telling him what is reasonable. But it seems to me that under our law, not only then did he have a right to represent himself, but he had a right to represent himself and decide on a foolhardy strategy that was probably more likely to get him convicted in a faster way than any kind of other strategy. Isn't that what Ferretta is all about?
Yes, Your Honor. And again, if you have to provide deference to the trial judge in this case, and we have support in the record that Mr. Pasha's request was equivocal, because we have prior Ferretta inquiries where they go, are you absolutely certain, Mr. Pasha, that you don't want an attorney to represent you?
And you'd say, well, I want,
I
but what you say in response, no, I do want an attorney, but I want an attorney who will advocate for my innocence, and you haven't been able to find one for me, so I have no other choice.
Your Honor, I cite numerous prior Ferretta inquiries where he doesn't equivocate. He says, are you absolutely certain you don't want a lawyer? Then after firing his second set of appointed counsel, and the Judge Timmerman is getting frustrated saying, you've told me you don't want an attorney, you want to go pro se, now you're telling me all of a sudden you want an attorney. What you're doing, Mr. Pasha, is delaying this case and dragging it out. This is a unique record.
Let me see if I can understand this. Now, the Ferretta inquiry is to take place if there's been an unequivocal request to proceed pro se, right?
Correct, Your Honor.
That's a threshold.
That is the threshold.
For the Ferretta inquiry. Now, we had the Ferretta inquiry here, and then all of this stuff that you're hanging your hat on comes after, or kind of at the conclusion of the Ferretta inquiry. Is that correct?
That's correct.
Well, so does that have a bearing on whether the trial court has abused its discretion here or not?
Yes, Your Honor, and that's a good point, because the trial judge is giving him the benefit of the doubt that this is a legitimate request. And isn't that the point of the Ferretta inquiry anyway? I mean, we're going to give him a chance to change his mind. We're going to advise him, go through a lengthy list of the reasons why you're much better off to have counsel. And that's what the judge did. And then he gets to that point where, are you absolutely certain you don't want a lawyer? He hears equivocation. And again, he has to make this decision, and it's a tough one, on the morning of trial, because that's what Mr. Pasha did.
But in fairness, I mean, in the Ferretta inquiry, the context there is the court is explaining to him all the reasons that it makes very good sense to have a lawyer, right?
Correct, Your Honor.
And then for him to acknowledge that, at the conclusion of that, is just to show that he understood what was going on. But the point here is that he can't get a lawyer who is going to represent him the way he wants to be represented, and therefore, as he ultimately says, it seems to me decisively, is that he's got no choice but to go pro se.
And again, that's where the state disagrees, because again, the point of the Ferretta inquiry, if the judge had just said, here are a few, cut the Ferretta inquiry off, the point is to give him that time, give him that chance to change his mind. And then what he hears at the end of this, again, I can't stress enough, this is a morning of trial request. 5 days before trial, they had a Nelson inquiry. Now, Judge Fuente said, I want to hear it before trial. If you have anything else, Mr. Pasha, he doesn't elect to proceed pro se. He waits until the morning of trial, October 22nd, and files this in open court. Now I want to proceed pro se.
I mean, I know you don't believe so, but I really thought in this record there was some place where the judge told him to put it in writing at the end of the other hearing.
He did. If you have any other requests, he didn't say, I want to represent myself. That's a critical. He said, if you have anything else. But this is a long hearing. And why wait until the morning of trial, which the state submits is untimely, and the judge was well advised based on this record to reject it out of hand. He had 5 days to sit there and know that he was going to invoke the right to to proceed on his own. But he didn't do that. He waited, and we have a pattern in this case. Ultimately,
But the way I see this is that he actually did that at the other hearing, and the judge says, that's not before me, put it in writing. And so, you know, you make a lot of this 5 days, but in the scheme of things, I mean, it just doesn't seem to me that it's...
I cannot disagree any more, and I made the specific quote. It's in my brief. He not once said, he said, I have the right to, this is what Mr. Pasha said, well, I have the right to proceed with counsel, or I have the right to proceed pro se. No clear, unequivocal request there. It's not even equivocal. So the judge says, let's hear it before trial, and he comes in on the morning of trial. This is a unique record. We have 3 judges, not 1, not 2, but 3, who have questioned Mr. Pasha's tactics in this case, in a case with overwhelming evidence of guilt. Judge Padgett,
Could that not be the problem? If it had continuity of judges, perhaps they wouldn't have been so frustrated. But each judge probably looked back on, well, this happened, this, and now I have it, and could that not play into why the judges might think it's...
That's a good point, Your Honor, because I think Judge Fuente was actually, would have been in a better position had he known fully all the prior machinations. He was generally aware of the history. But remember, you have Judge Padgett instructing him when he's complaining, I'm not ready for trial, I'm not ready for trial, can I have another 90 days? And this is in August of 2006.
But we're not, this issue, the judge didn't find it was made, that the motion was made for the purpose of delay. This is the, going back, the Nelson hearing occurred on October 17th.
Correct.
The defendant at that point, after the trial judge said, I'm not going to discharge Mr. Sonardi, the defendant then says, as a right, I have a right to have a lawyer appointed if I can't if I can't afford one. I also have the right not to have a lawyer to sit with me if I don't want to. And that's when the court said, that's not before me right now. Right now you filed a motion to discharge Sonardi, Mr. Sonardi. I've heard everything there is to hear. I've denied it. If you have another request, you know, I honestly put anything you want me to consider in written form, and I'll promise you I'll hear it before trial. Yes, sir. I assure you of that. Well, this is, so that's what the judge, is that not exactly that he was saying, I want to proceed pro se, and the judge said, put it in writing, and I'll promise you I'll hear it before trial?
Your Honor, one thing we know about Mr. Pasha is he speaks up and he speaks out. He's not shy and retiring. He will let you know. He's pondering his options. I don't know how you read that and find that he was invoking his right to proceed pro se. If he had, we could have had an orderly process and maybe a hearing right there. But instead, he waits until the morning of trial. And even then, the judge gave him the benefit of the doubt. And I disagree, Justice Pariente. We ultimately have a finding by Judge Fuente that he, after 2.5 days of jury selection, when Pasha says, it's my firm and fair and final decision, I want to proceed pro se, there is a specific finding by Judge Fuente that it was untimely and dilatory.
At that point, right.
That's correct.
That's after he renews it during voir dire, which is another question, and then during opening statement. So the other part that, again, as I said, I am sympathetic to your argument. I'm not, honestly. When I read this case, I said, oh, no, not another one of these situations, because the defendant, it's never a good situation for the court system and ultimately probably for the defendant. So I appreciate that. But at the same time that same hearing, I think, October 22nd, I still go back to Mr. Sonardi saying, I'm still at a juncture of whether or not I'm going to be able to represent Mr. Pasha on a theory of second-degree murder versus not guilty. Again, I'm still at that juncture. My professional opinion is that Mr. Pasha's best opportunity to avoid a death penalty in this case would be second-degree murder, so I'm still stuck with that. And he keeps on talking about how he's on the horns of the dilemma professionally. And I don't know if there's another case which has that unequivocal a statement by the defense lawyer that he really has to go with that strategy or will have ethical problems. And I think that backdrop to me is an important factor that I do believe they've read too much into Nixon if to say that a defendant, knowing what the trial strategy is, has to just go with the trial strategy that the defense lawyer says, or that's it. So that's my additional concern here.
And, Your Honor, I think if you had a different defendant, one who did not have Pasha's history, and that this all of a sudden came up on the eve of trial, you would give Mr. Pasha the benefit of the doubt that this wasn't just a maneuver to delay his long overdue trial. But we have a history here. We have Mr. Pasha repeatedly discharging competent attorneys, waiting until the eve of trial, having the same conflict he'll have with every attorney who ever may be appointed to his case, and then 5 days prior to trial, they have a Nelson hearing, and then morning of trial, this motion comes up. So, and given that history, I think we have to defer to the trial judge and his discretion at that particular time. And again, it's a difficult question, but we have time to sit here and parse his words out and consider it. And that's why it is an abuse of discretion review. If reasonable people can differ on the ultimate resolution.
In this kind of situation where you are stating that Mr. Pasha is the type of defendant who's going to have a problem with all of these lawyers, it seems to me the better thing to do in a situation like that is when the trial judge says there's nothing wrong with this lawyer is being effective, go through the Ferretta inquiry and say, I don't think this is in your best interest, but you have the absolute right to do this, and just let Mr. Pasha take the chips as they come by representing himself.
And that was one possible outcome, but the judge was concerned that it was an acquittal request. And the last Mr. Pasha said on that morning of trial inquiry was, I'd love to have an attorney. So he's probably thinking, no matter which way I rule here, I'm going to be reversed.
But that really is the situation when a defendant tries to dismiss an attorney, the trial judge says, no, there's no good reason to dismiss this attorney and have another one appointed by the state. Most of these defendants really would rather have an attorney, the one they want. But when they can't, they go on and proceed pro se. We see it more times than I think we should, but that's the state of the law. And the trial judge in this case, I think, just took it beyond what our case law requires.
So the entire history of manipulation in this case, the three judges who had questioned him, his best tactic, you know what Mr. Pasha's best tactic was? He can outsmart everybody. Delay. He's caught red-handed with bloody murder weapons.
If the judge didn't, I think this is I guess we can affirm on a ground that the judge didn't find, but the judge didn't find that the motion was made for purpose of delay, and you're absolutely right that there's case law that says if it's determined that the motion is made purely to manipulate purposes of delay, then the trial judge has a right to deny the request. But you're asking us to interpret or make a decision that the trial judge didn't make. He didn't say, well, you're trying to delay again. And as Justice Perry said, it may be a combination. This man went through, he had all these different judges. All of them were sort of telling him things, you really should have a lawyer, even though the 2 years he didn't have a lawyer. He apparently was getting on fine. And so you got that as well. But that's my concern, is that the record, if the trial judge made a finding that it was done for purpose of delay or manipulation, you could say the record supports that. But the judge didn't make that finding.
And that's an interesting point.
Well, did the judge make that finding?
He ultimately made that finding. And again, if you look at the two rulings in isolation, on the 24th, after 2.5 days of jury selection, I'm finding this late, dilatory, simply for the purposes of delaying this trial. Now,
that's a different matter. That is entirely distinct from his initial determination that the request was equivocal. And so that I think you have to go back and analyze whether the status of that initial request, and he certainly made no finding and did not say anything in connection with that request and that initial determination that indicated that he believed it was for delay.
Well, no, and there's no specific finding, and I've never made that representation, but I think the history warrants that finding. But
during the November, on that point, before we get away from it, on the November 29th hearing, where Mr. Pasha indicated, I always wanted a lawyer. The court did make on the record the following statement. I am frankly beginning to wonder, Mr. Pasha, you're not a stupid person. You say you don't want the lawyer, then you say you do. You don't want one then, you do now. What are you doing? What you're doing is dragging this case out. The court did make that statement.
Exactly. And Judge Padgett also made that statement earlier when he was quibbling about his discovery, and he's never ready for trial. In March of 2005, the judge says, let's get this thing ready for trial. Oh, I'm not ready, Your Honor. Don't put it on the calendar. So for 2 years, he represents himself and then changes his mind. Oh, I love to have a lawyer. I want to have a lawyer. And again, you can't look at this case in isolation and go, give Mr. Pasha the benefit of the doubt, because we have a history where he has not earned that benefit.
Well, I thought that and this is, the record is there, I thought that the point when he asked for the lawyer or said that he would take a lawyer, that it was the state that had additional evidence that had been discovered. Is that inaccurate? In other words, it was ready to go to trial, and then the state came up with some additional evidence. That's what Mr. Bolatin represented. So Mr. Bolatin usually is pretty accurate in terms of what he recalls.
Your Honor, I'm not sure if that was that hearing date. What the record reflects is that in the 5-year delay that it took for this case to get to trial, one delay of 1 to 3 months was attributed to the state. That's it. And we can go back and look at every time he changes counsel, there's a year delay. You're built in a year delay. And Mr. Pasha knows that. He fires his first competent attorneys, second competent attorneys, there's another year. Represents himself for 2 years, another delay. It's solely attributable to Mr. Pasha. Then when judges are getting tired of dealing with him and saying, look, this is an old case, Judge Padgett, we've got to get this to trial, Pasha says, oh, wait a minute, I want a lawyer now. So his maneuverings were his best strategy in this case. But
I think you have to agree, though, that at that hearing, the state did come in and say, we have this video of the crime scene, and we want to look at it more closely. And
Correct.
So there was that point. And at that point, wasn't it at this point also that Mr. Pasha says, well, I want a lawyer, or because I need a lawyer to look at these pictures or something to that effect?
I thought that hearing came later. That was in November. I believe in August of 2006, they were discussing a trial date.
Okay, so it was in August that the state says, I have this tape I want to look at more closely?
I believe so, and I could be wrong.
And so then
but
just
I don't
3
think...
months later, Mr. Pasha asked for an attorney.
Yeah, in the November hearing. And again, when that occurred, Pasha didn't say I was ready for trial. In fact, to the contrary, he said I could have 90 days. How about 90 days out? He's not saying I'm ready for trial. He never once said that. He said maybe I could be ready for trial if I had all my discovery materials. If only I had all 5 boxes of material, I could get ready for trial. So I think it misrepresents the record to say that the state's one delay of anywhere between 1 and 3 months excuses Pasha's 5 years between flip-flopping on the issue of counsel. And again, that's pretty much why we make that a discretionary call.
For purposes of FREDA, do you look at each stage of the process before trial, so that if you have 5 different FREDA-type hearings or evaluations that go on, if there's an error at any point in time along the way, is that automatically reversible error? How does that work?
You know, I don't think it would be. I would agree with Mr. Bolatin on that. I think if you had an error at a which wasn't a critical stage in the proceeding in FREDA, that would have no impact upon the case whatsoever. The prior FREDA inquiries are only important in this case because they show that Mr. Pasha knows how to unequivocally elect to represent himself. He's none of this, I'd love to have an attorney. Oh, no, I never want to be pro se. He knows how to do it. He is gaming the system. And again, that's his best tactic in this case. The state also would like to briefly mention that this court has not specifically articulated a timing requirement for a defendant to invoke the right to self-representation. And I've cited a number of jurisdictions. What is clear to the state is that a proper rule would be prior to trial. California requires invocation a reasonable time prior to trial, or it is entirely in the sound discretion of the trial judge. The better rule, perhaps, is somewhat more lenient to a defendant, is that the defendant has a clear and unequivocal right to represent himself if he invokes that right prior to the day of trial.
But doesn't Beretta require that the inquiry be conducted at each critical stage of the trial?
I believe there's subsequent case law requiring it. Again, you offer counsel for sentencing,
but that critical stage of the trial, that would be voir dire, I guess. That would be opening statement. That would be motion for acquittal. I mean,
Your Honor, it's interesting. I don't think that's true. That's correct. But what Ferretta requires constitutionally and hasn't been interpreted by courts of appeal is a reasonable time prior to trial. If a defendant unequivocally elects the right to proceed on his own or pro se, then he has that constitutional right. But if he doesn't invoke it a reasonable time prior to trial, the judge has discretion to deny it, as he did in this case.
What is the use in the requirement that the Ferretta inquiry be conducted at each critical stage of the trial if it doesn't matter after a jury is selected? What I'm saying is, let's say that critical stage of the trial is, opening statement or closing argument. If at closing argument time, if I give the defendant, and if I conduct a Ferretta inquiry, and he says, okay, Judge, I just realized I'm over my head, I want a lawyer. And if what you're saying is, any time after the jury is selected, you're by yourself.
Yes, Your Honor.
What's the use in having to conduct a Ferretta inquiry?
You can't flip-flop. And again, jury selection is a critical part of the trial. I don't think Ferretta stands for the proposition that, prior to jury selection, if you have one full and fair Ferretta inquiry, you have to repeat that. I would say in a capital case, you're well advised to prior to sentencing. But one full and fair Ferretta inquiry. But again, the greater weight of opinion seems to give, I'm in...
Well, you can finish your statement.
Well, the greater weight of authority, and I've cited Minnesota and some other states, Indiana, they require a defendant to make that choice prior to trial. Because, again, what you have in this case is a rushed procedure. The judge has to make the determination when the jury's there. The state has marshaled its resources. We would ask that this court articulate a timing requirement. Thank you.
Mr. Bolatin, as counsel has indicated, he considers you a very competent lawyer, and I think the court does as well.
Thank you.
If we are dealing with, just this isolated portion, if a defendant in a case says, as I've indicated, Judge, to you all along, that I'd like to have a lawyer, I definitely would rather have a lawyer, but I have no choice. Is there a Florida case that says that's an unequivocal, as a matter of law, an unequivocal statement that I want to represent myself?
I think probably the closest case to it in Florida would be Weaver. Now, I've cited a number of cases from federal and other state jurisdictions that deal directly with that. First of all, with the question of a conditional request, saying I'd like to have a lawyer in theory, but not this guy. Adams versus Carroll, Minnesota case Richards, the state of Washington.
We don't have one yet that specifically says that.
From
Florida. You say Weaver.
For that proposition of law, let me see here. I have cited the best case on it is Adams versus Carroll, which is quoted in length in my reply brief. United States versus Allen from the Ninth Circuit.
So we then do have, that's as a matter of law, those words require that trial judges allow a defendant self-representation.
Those words are an unequivocal request. The cases say just because it's conditional, in other words, just because it's in response to the Nelson ultimatum, doesn't make it equivocal.
Okay.
And
well, apparently that's not clear to our trial judges. We haven't said it loudly and clearly enough, because if that is the law, because you're taking the position this is as a matter of law, this is not a factual, this is not a part law, part fact, this is a matter of law. then apparently we haven't said it loudly enough. The trial
I would
judge
invite the
should say.
court to say that loudly and clearly.
Okay.
But
Well,
interestingly,
because the next time you're going to have someone here who does not have a lawyer, and in a different situation, the Sardi, the fight, certainly this is not a Nixon situation, and that fight sort of colors what we're talking about. But we're going to have others that are going to follow this that don't have that clear-cut
That's
problem.
true.
And so I think that our job is to clarify, make sure the law is clear.
Well, I would cite to my initial brief at page 42 and 43 for a number of cases on that. But what I think is interesting is when my opponent was asked, did he have any case for his position that it's an equivocal request, he cited Hardwick v. State, the only case he cited. In Hardwick, quote, the record reflects that Hardwick repeatedly asked for new counsel, admitted his incompetence to conduct the trial, and stated, I'm not choosing to represent myself. That's pretty unequivocally the opposite of what we got here.
Well,
now.
you also have, this was the hearing that followed. I mean, the motion, no one's arguing, the motion itself was unequivocal that he filed.
Right.
The written motion. Do you want to address just the 5-day delay? Is there an issue on the 5 days?
If I have any time, I really want to talk about the time
you only
in the
have 30
sequence.
seconds.
First you got the Nelson hearing at which he starts to say, well, given how you've ruled, I have a right to a lawyer, but I have a right to not have a lawyer. And the judge cuts him off and says, I don't want to hear that now. That's not before me now. File a motion. I promise I'll hear it before trial. He filed a motion. It was heard before trial. Everything's fine with timeliness. Now, as far as, I have to rely on my brief on this. There are Florida DCA cases and cases from Texas, Virginia, the 11th and 5th Circuit that would say even his renewed motion made during jury selection but before the jury was selected and sworn, even if that had been his initial request, that would have been timely. Now, I agree with the state that the cases from various jurisdictions are all over the map on that, but the Florida cases, which are the DCA cases, which if the defendant was going to go by anything, those are the cases he would go by, pretty clearly indicate that even the renewed request during jury selection was timely. This was a renewed request. Again, he was as unequivocal as he could be. It was completely understood. If my only choice is Sonardi, I want to represent myself. I also want to make the point that I don't even know how Mr. Pasha would have benefited from delay in this case. He was in jail. He was not getting bond. He was not going anywhere. He didn't care about, Mr. Pasha's concern was an acquittal. And the only time this case was, they talk about in their brief about the eve of trial. He keeps changing his mind on the eve of trial. There was one eve of trial. He was invited to change his mind, and he didn't. There was no indication, given the good faith reason he had to have a problem with Sonardi, there's no indication of delay or insincerity or manipulation. Thank you very much.
All right. Thank you both for your arguments. The court really appreciates your contribution to this case. Thank you. The next case on the court's agenda is Ka'a.
Mark Newmeyer representing the appellant, Catherine Ka'a, in this matter. As the court has reviewed from its examination of the record in the brief, this case unusually presents an isolated issue of law for determination by the court. The facts below were basically stipulated. It was the application of the law to these facts and the proper standard of review, the proper application of the statute that were squarely before the court below. As indicated, the policy and the case law in the first DCA under the Stevens case has been once marital efforts, funds, labor are used to create a marital component of a non-marital asset under the statute, any subsequent appreciation of the entire asset should be prorated between the non-marital component and the marital component. Side issues relating to the Stevens case are what kind of contributions create a marital asset. That particular case talks about taxes, payment of taxes. Those side issues may or may not be ripe for determination, but the basic question of whether passive appreciation of an asset that has become in part marital already and subsequently appreciates is distributable as marital asset is squarely before the court. In the Mitchell case, cited by the second DCA in support of its ruling below, if you look at that case, there is a flat statement without explanation as to policy reasons that a marital component was created by the pay down in the mortgage, and that is the amount that is limited, that the distribution is limited to, without really giving any explanation, any consideration, other than the fact that earlier in the decision there was a finding, or a recitation at least, that all of the passive appreciation in that case was attributable to the growth in value of the land itself, as opposed to any renovations. It submitted that this was a rather cursory examination of the issue. They didn't really look at the question that's in front of this court, and yet that case has been cited in case after case in the second DCA leading up to this case. It's our position that the statute clearly requires that the court determine a marital component and that it distribute it, and that marital component is defined as marital enhancement and appreciation. The position of the former husband in this case, the appellee, is that those two terms are synonymous, appreciation and enhancement. But clearly, if you look at the statute, it is appreciation, it is enhancement and appreciation. Their interpretation of the statute and the interpretation, I guess, of the second DCA in the Mitchell case is that the words and appreciation have no meaning. That there is, once there's an enhancement, you ignore any appreciation. That all just stays as non-marital.
Well, isn't it that, I mean, I guess that their position would be the appreciation. So you're saying the enhancement in value was the carport being put on.
Yes, Your Honor.
Appreciation has a different meaning under the law.
Yes, Your Honor.
And in accounting, I would assume.
That's our position, Your Honor. If the statute stopped with the word enhancement, then it might be more difficult to make the case that the Stevens approach is preferable and complies with the statute. But the words are there. It says enhancement and appreciation. It must be interpreted that all the words in the statute mean something. And the Stevens policy, the Stevens case law, does recognize and place a meaning on that, which is reasonable and in our position, equitable, particularly on these facts.
I mean, you would, as far as you, because we may or may not decide the issue of how it's determined, because, again, you have a situation where maybe most of the down payment is made before the marriage, and there's very minimal mortgage payments, and then there's just a spike in the real estate market, which unfortunately we don't have to probably worry about this issue as much anymore. But
yes.
that may be different. That's a very different situation than here, where you've got a 27-year marriage, you've got all of the mortgage payments, taxes, whatever, being paid by both parties throughout the duration. So it really has to be a factual determination by the judge as to what extent the contribution of marital funds had on the appreciation of the non-marital asset.
Yes, Your Honor, absolutely. This is always going to be an intensely fact-specific computation, but there should be a policy that covers both situations.
Does it matter if it's the marital home versus that it was an investment property?
I would submit that it doesn't. There's no distinction within the statute for homestead versus non-homestead.
I guess I was just thinking expectation-wise that a wife lives in the home, she's contributing equally, during the marriage. She gave some money beforehand. The expectation would be that that home is their home.
Yes, Your Honor.
It's not titled in her name versus something that might be in a vacation home in another place.
Yes, Your Honor. And I actually made the argument at the DCA level that it would have actually been better for the wife in this case if they weren't married, because under constructive trust theory, there are other policies, other case law that would support her if the court had found that she had contributed to the part payment, the down payment before the marriage, and that she had an expectation that she would have an interest. She actually would have been better off than getting married in the second DCA, where she is absolutely stripped of any rights to any subsequent appreciation. But again, our position...
I guess they didn't buy that argument.
No. But again, it was simply to show that there is no policy reason to apply the Mitchell case so as to strip any right to any appreciation in the marital component of the asset. The fact that it's going to be fact-intensive, if you look at different scenarios, for instance, let's suppose in this case there was a lump sum payment. Let's suppose on the date of the marriage it was worth X, and there was a balloon note that was valued, that was to be paid 5 years later. So not until 5 years into the marriage was there a contribution. Then I would think you would look at what was the fair market value on the date the payment was actually made in that particular case, to determine what percentage of equity was created by the marital payment. We don't need to get into that. All we need to do is make a determination generally. Is there going to be some right once that marital estate is created? And if you can do the fact-finding of valuing it, you can present the evidence that the property was appraised when it was refinanced, the property was appraised, or in some other manner, you find the evidence to prove the value on the date when the marital component is created. If you can prove that there is subsequent appreciation, should it be prorated between the parties? And that's really the issue that we have before us.
But if you get it to such a broad proposition, I mean, that in and of itself could also lead to inequities. I mean, just as it's been held right now that it's inappropriate the way that it's presented to us today.
Yes. You
take the reverse without qualification, then that also creates inequality. So it seems to me is that you can't just do it. You're going to end up with 5 different districts all doing it different ways, and individuals not receiving equal protection under the law in each. So it seems to me that it has to be qualified in some fashion.
Yes, Your Honor.
So that circuit judges, where you are, do it the same as circuit judges in Miami, so that we have uniformity. Isn't that's the purpose, isn't it, of this entire civil code now that we have with domestic relations?
Yes, Your Honor. It's how you implement it.
Well, sure. I mean, that becomes an important part.
Right. And our position is that the Stevens case, the Stevens procedure of looking at a percentage of equity and multiplying that percentage, the reasonable proration, by the subsequent appreciation of the property, it would cover both scenarios. If a property comes in that is almost completely paid off, and there's 2 little bitty payments that create a tiny percentage of marital estate or a marital asset out of that non-marital asset, when it comes time to look at the passive appreciation, the non-owning spouse is going to get that tiny percentage of the appreciation, whereas in our case, when 100% or close to 100% of the equity is created by marital payments, that proration, that reasonable proration, will be applied to the end. So it's our position that the Stevens procedure, I guess you would call it, kind of covers both ends. It may be subject to tweaking. Again, the Stevens case talks about payment of taxes, which most other jurisdictions deem to be, and even I believe the same district deems to be, carrying charges. If it doesn't create equity, then it's not going to create any marital asset, which would be entitled to marital appreciation. But again, I don't know that we really need to cover carrying charges today, because the principle itself in this case was almost entirely marital. The actual mortgage used, the purchase money mortgage was replaced with a marital mortgage. So the entire purchase price other than the down payment and whatever principal was created by 6 months of mortgage installments on a 30-year mortgage. All the rest of it, including all the carrying charges, the mortgage pay down, the renovations, all was marital. So for an application of the law to be made which results in the non-owning spouse receiving no benefit of any of the appreciation of this asset, the marital asset, to our perspective is inequitable.
Well, on the issue of what the formula would be, there's a recent case out of the 5th District, very recent, Leader versus Leader.
Yes, Your Honor.
They agree with Stevens as far as the underlying proposition, but, and I'm not, I would defer to other people on accounting, but have they applied a different test than Stevens?
They've applied a different procedure for determining it, and I've looked at that case, and to me, it's kind of an accelerated proration because they start with what's the principal balance of the mortgage, and then unlike the second DCA or the Stevens case, they don't take principal reduction and use the principal reduction to create the proration. They actually use payment, principal and interest, and deduct that against the principal. So it's like an accelerated increase in the marital portion of the asset, as best I can tell.
Basically, so the Leader decision would be more favorable to the spouse that's claiming a part of it's a marital asset. Is that what you're saying?
I would read it that way.
But it sounds, I mean, again, so there is already a difference. Are there any other formulas that the other district courts have used that are vary from Stevens?
The other formula is just as bad on the other side, which is once you prove any marital component, then all of the appreciation becomes marital and subject to distribution, which, as Justice Lewis indicated, if most of the equity, if there's that little tiny payment, then why is there a policy reason to justify?
Which court is that from?
If I could, Your Honor. That was actually cited in the Mitchell case. That was what they were so mad at, I think. In the Mitchell case, the wife there was pushing that case law from Sizemore, which is 50 CA at that time. And of course, now we know 50 CA has changed its approach.
Did you read the 4th District Court of Appeals decision in Raffinallo?
Yes, Your Honor.
There, they addressed the concerns that you were raising about how Stevens provides a fast and hard and fast rule that just because there's a marriage that she or he is automatically entitled to the passive enhancement. And they have dedicated some factors that perhaps should be looked at rather than having a fast and ready rule.
Yes, Your Honor, and I believe that I would kind of disagree, although it's hard to disagree with the 4th District in interpreting its own decisions, but I didn't read Stevens as setting forth a hard and fast rule. They said generally you should do the following. The general rule is this, but it's always subject to consideration of the other factors.
Like factors like the length of the marriage, whether marital labor, money, or both were used to enhance the value of the property, and then they mention any other equitable factors.
Yeah.
So that they're giving trial judges some discretion in deciding whether or not, because someone can get married and 2 weeks later there's a divorce, and under the Stevens case, it seems like he or she is entitled to a passive enhancement.
Right. It could also be that under the Stevens case, the parties get married, there's a purchase immediately before the marriage, like in our case, and there are huge interest-only payments throughout the course of the marriage while the property skyrockets in value, and yet there's no principal pay down. So there are different scenarios where the court can use equitable consideration. And I don't read Stevens as having a hard and fast rule. I said, my understanding is, and my argument is, it's reasonable proration. So you start with some percentage. You determine, first off, was there a marital asset component of this asset due to the contribution of marital efforts or funds? from that time period, was there subsequent appreciation? If there is, then you need to apportion that in some way.
But you agree that Stephen has a hard and fast rule that provides for entitlement?
Yes, I would say that if there, unless there's unusual equitable reasons not to.
The fourth and the fifth do not have an entitlement component.
I
There's
would.
some discretion among the court using the factors they've listed.
I believe that the Leader case kind of, for the first time, indicates that there's an entitlement because they did reverse, if I'm not mistaken. That's where it all comes down to, yes, Your Honor.
So it seems there's a difference between giving discretion on how to compute this according to the statute.
Yes.
And we could sit here and probably amongst us come up with a lot of different formulas in a lot of different ways. As you indicated, the situation of a balloon payment, you could have refinancing occurring during the course of a marriage, all kind of factual circumstances,
Yes.
which may enter into an appropriate computation under the statute.
Yes, Your Honor.
But then it's an entirely different thing to say, are we going to actually award what the statute provides or not, and give different considerations as to whether that particular award is going to occur or not. I'm suggesting that maybe the fourth and the factors that it determines as to look at these additional things to decide whether or not you're going to award this to the spouse may be factors not considered within the statute and therefore perhaps inappropriate.
I believe, Your Honor, that if you look at the factors cited in the Raffanella case, they are the same factors in Section 1 of the statute, which is you generally start with an equal distribution, but it's based on, unless there is justification for an unequal distribution based on all relevant factors. That's where I read this discretion coming in. It would be almost like we need to know where we start, so we have a general rule.
Well, you start, though, with that this was a non-marital asset.
Yes, and then you have, by definition, if there was a marital component to the creation of equity in the property, certainly, then there is the asset becomes in part marital.
Well, so conceptually here, we've got two distinct steps. One, you've got to determine the value of the marital asset.
Yes.
And the amount of appreciation that would be put in that category.
Yes.
That's step one. Second step is to decide how that's going to be divided between the parties. And the different factors come into play in those two different steps.
Yes.
Is that correct?
Yes, as there always would be. Let's suppose that the court has a Stevens case, a final judgment in front of it. There has been created marital asset out of a non-marital asset. There has been an award of a portion of the prorated appreciation in value. So we're starting off with the Stevens case. But the court can say, but I'm going to give an unequal distribution because there's a business over here or because of any of these other reasons. So the final award is always subject to this modification. It's not this appreciated asset is going to have its value modified unless that's the only asset, then yeah. But my position is the statute permits the court and requires the court to at least consider doing that anytime there's a request for an unequal distribution anyway.
Mr. You're well into your rebuttal. You have about a minute left if you want to save any time.
Very well, Your Honor. Just very quickly, what I would say is the problem with Ka'a'a in the Stevens case is it takes away all discretion to the court to award any of this. There's a hard and flat rule. No appreciation is distributable, period. Just the pay down in principle. So where we are right now, the reason we need reversal is we're at the wrong end of the spectrum. Thank you.
Thank you.
May it please the court, I'm Ellen Ware. I represent Joseph Ka'a'a. And first of all, I want to make sure that it's clear that our position is, my position is, that the equities do favor the result reached by the Second District and by the statute. They favor the application of the plain language of the statute to the facts in each case. And so I don't want to say, oh, it isn't equitable, but we need to do it anyway. I want to say in this particular case, I think it is equitable, and I can go through the reasons why it was, although the equities weren't tried because there was no prayer for an unequal distribution. And that's where the equities come in, is when you're asking for an unequal distribution based on some equitable principles.
How does it comply with the statute?
It complies with the statute because the statute provides for a marital excuse me. The statute requires that marital assets and liabilities will include the enhancement in value and appreciation of an asset resulting from marital efforts or monies. And this is really important because if you read the Stevens case, you'll note that the Stevens court says we have to figure out what to do with the appreciation resulting from market forces, not the appreciation resulting from marital efforts and enhancement, but resulting from market forces.
Well, let me ask you this. If a property is mortgaged, isn't it a prerequisite to enjoying the appreciation and the value of the property that the mortgage on the property be paid? And so isn't in a very real sense it true that you can't enjoy the appreciation unless the mortgage is paid? And if marital assets are used to pay the mortgage, doesn't that mean that that appreciation has resulted from the use or the contribution of marital funds?
And the answer is sort of yes and sort of no. I mean, obviously, if you have a property and it has a mortgage, it also has taxes. You also have to pay for insurance. There are a number of things you have to pay for if you have a piece of real property, and if it has a mortgage, the mortgage is one of them. And this is an argument that has been attempted occasionally. But for everything you pay for in this house enables you to keep this house, right? I mean, you have to pay your mortgage, you have to pay your taxes. The taxes argument has been specifically rejected by I think just about every court because it doesn't enhance the value. The mortgage, what has been done by the second and by the third and by the fourth in most of their cases, and in every district in at least some cases. I mean, every district has done what the second has done, which is an application of the plain language of the statute. Every district has done it in at least one case, many of them and more.
Well, but we're here because there's a conflict. And you, in your answer to what Justice Kennedy said, you were using whether there's been an enhancement in value. And would you agree that there is, if the legislature didn't intend for passive appreciation to also be included in marital assets, that they could have stopped with enhancement in value? So my question to you is, what is the difference from your point of view, what you're trying to argue, between what the legislature meant by enhancement in value and separate from appreciation of non-marital assets?
Yes, there is a difference. And if the legislature had wanted to include passive appreciation, they would have needed to say something about the appreciation resulting from the market. They limited it to...
No, what I'm asking you is, what's then the difference? What would be an example of an appreciation of marital assets different from enhancement in value?
And we have that in this case, and we have it in lots of cases. You enhance the value of your home by investing $10,000 in an addition. And when you invest in it, you enhance the value by $10,000. That $10,000 then appreciates. When you get to the end of the case, like in this case, the parties had added a room on to the property. And, there wasn't testimony about precisely how much it cost them or what the value was at the time, but obviously the property had increased in value substantially. And the amount that was determined to be marital was the value of that property at the time of the dissolution. So say, if you invest in, adding a room onto your house, and at the time you add the room onto the house, you pay $10,000 for it, and, it's worth $100 a square foot. If there's appreciation in the property, so that by the time you get divorced, it is worth $200 a square foot, you get all that appreciation for that addition that you made. You enhanced it. You get the appreciation on that enhancement. But what you don't get is, and I want to get back to Justice Kennedy's question, because, paying the mortgage down is kind of an odd thing. If you're living in the house, the law in Florida in family law cases is, after you're divorced, if you are entitled to exclusive use and occupancy of the house, you may or may not, depending on the cases, and there's a whole line of cases starting with Kelly, but you may or may not be required to pay the reasonable rental value of that house because, you're living in it together and so forth. The marriage is getting a benefit from living in this house. Mr. Ka'a, for instance, could have rented this house out. The testimony was that by the time they got divorced anyway, the reasonable rental value of the house was probably far greater than what the parties were paying in mortgage. So, the marriage, it would not be an unreasonable application of the law to say, hey, if you pay down this mortgage, you're just getting something for it. You're getting the ability to live in this house.
But the way you seem to argue this, it seems to be that this is an easy thing when you add on an addition to the house, whether it's a room or a carport or whatever. You end up, in my estimation, with a different structure, which means that the value of the house really changes a lot more than just the value of that one addition. And so to me, it's much more difficult than what you're saying is to look at that one addition and see what that addition's value is, as opposed to how the entire structure has been enhanced by that value.
And I think, the testimony here by the real estate appraiser was the amount by which that addition had enhanced the value of the home. And I think, however, I would agree with you that if the value of the home were enhanced more than just by the square footage, that would be something that should be included as marital. I'm just using that as an example for how you can invest in the home. The marriage can invest in the home, enhance the value of the home, and then you have the appreciation on that enhancement.
So your position is that contribution to or expenditure thereon, that mortgage payments, whether you do principal and interest or interest only or principal, is not part of what causes the appreciation of the non-marital asset, and that's clear from the language of the statute.
I think the second district has said that if you pay down the mortgage, essentially, contributing to this non-marital liability, that pay down of the mortgage is an enhancement of the property. That's the way they've looked at it. I don't think that's an unreasonable application of the law.
Enhancement or appreciation of the asset.
That is, they have called it enhancement. It is essentially a marital payment of a non-marital liability.
But all they attribute then is just whatever you actually paid. They don't attribute anything either to enhance value or appreciation. That's why we're here.
That is correct.
But it's difficult for me to understand how you can even get to a point of separating all of this. I mean, if you have the marital asset, a non-marital asset, but he had it, for 6 months prior to the marriage. And so for 27 years, what they collectively had was paid to pay the mortgage, to do the enhancement, to keep up the property, do all of this. And it just, how in the world, what kind of formula can you even come up with that separates all of that? I mean, can you start with, okay, the percentage of the mortgage that was paid prior to the marriage, and then the percentage of the mortgage that's paid afterwards, and so can that be what it becomes the marital asset, including that percentage being what the appreciation is also? I mean, I'm having a real struggle here with how you're going to separate all of this, especially when you have a long-term marriage and a short term of having the property that is really non-marital.
And a couple things I want to talk about this particular case. But yes, I mean, it's, the statute has no formula in it. It has no suggestion that there should be a formula in it. The statute says simply the enhancement and appreciation resulting from marital efforts and enhancement. And if you look at Stevens, they're talking about what to do about the appreciation resulting from market forces. The language of Stevens makes clear that the statute is not being applied there.
But, you know, if you take the scenario that the person who purchased this property did not have the money to pay this mortgage of it on its own, how in the world do you separate then the effort that both parties put into it to keep it? There would have been no appreciation, market or otherwise, if the mortgage could not be paid. Isn't that true?
Right. And I think one of the things that makes homes different than another asset that maybe has a debt on it or something is that another alternative was always for Mr. Ka'a, who testified that he purchased this home as an investment. He could have rented it out. And in fact, there's some cases where they talk about how, and I wish I could remember the name off the top of my head and I can't, but there are cases in which, you know, courts have found, you know, you have a property, you rent it out, you use the income from that rental to pay for the home, and it stays non-marital.
Was she, the house was financed multiple times. Was she was never on the title for the house. Was she ever on the mortgage?
The testimony of Mr. Kawa, she was never on any notes. She never had any liability. I assume that she had to sign the mortgages because most mortgage companies will make her sign so that they can foreclose if they need to. But she never had any liability on it.
What do you mean she was on the note? I mean, you said something about you assume the mortgage company would require her to be on
the mortgage company, as I understand it, and I'm not a real estate lawyer, so I apologize, but as I understand it, mortgage companies, because this comes up in family law cases all the time, if there is a married couple and one of them takes out, particularly on a homestead property, takes out a mortgage with a note.
This was homesteaded? This was a homestead property?
I'm assuming it was. I don't think there was any testimony about that one way or the other. But she did not sign on the note. She didn't have any liability on it. And you know, Mr. Ka'a could have rented this property out.
But he didn't rent it out, and he didn't segregate the payments. Again, the facts here are, I guess, you know, again, we have to make sure we look at a rule for all cases, but is this correct that he purchased the home for $36,500, but all he had at the time of closing was $2,000 down?
Right.
That's correct?
Which was a little more than 5%. That's not an unusual amount.
Well, that's
yes.
Okay. And then there was also, she testified she actually contributed $500 to that amount.
Her testimony was equivocal. She had said one thing in deposition, a different thing
in
trial. He testified no, and there was no finding by the court that...
And then, no question, though, the remainder of the purchase price was financed with a mortgage,
right.
Correct?
Right.
And during the time, the mortgage was paid by marital funds.
Correct.
He could have chosen, just like you say, someone decides they want to keep an investment property separate. He could have decided to say, listen, I'm going to be putting this out of a separate account. This is an investment property for me. I mean, he could have made that clear that that if he wanted to keep something as investment property, but he didn't. Marital funds for the whole 27-year marriage were used so that by the end of the time, the remaining balance was only $12,000, and the house had gone up to $225,000.
Right. And
it just seems like this is sort of a bait and switch here as far as what the party's expectations would have been.
Well, the testimony was very clear that the expectation was he was keeping this in a separate name. He had been married before. He had 2 sons. There was no question that this was something he had purchased for an investment, that he had intended to, keep it for himself, which is why he titled it separately. You know, the general public believes you keep something titled separately, you keep it separate, it remains your separate property.
But then he should have paid for it separately.
Well, and, if the law becomes, the law in the 2nd District has been clear. I mean, every case is clear, from the inception of the statute in the late 1980s through today. The law in the 2nd District is clear that that, if you have a non-marital asset, you pay down the mortgage, that doesn't make a portion of what the market does to your property marital. If that changes, perhaps people will act differently. And one of the things I raise in my brief is the possibility that will cause people to act differently in terms of you have a separate asset, you have a separate non-marital asset, you rent it out, and you use that money to pay for it. Mr. Ka'a had a small amount of stock. Maybe he could have used that to pay it if that had been the law. He could have rented it out. That was an alternative. But that would have left Mrs. Ka'a paying probably more in rent if the parties had rented than she had to contribute as a married couple, as they had to contribute to the mortgage. It would have left her without any equity in the home, because she had, at the conclusion of this, she had some $36,000. I mean, there was $36,000 in marital funds, and she received half of that. She would have, if the law were different and he had kept that home separate, paid for it separately, I mean, it has a value, that rental.
So for 27 years, she ended up with $18,000.
For 27 years, she ended up
with... He ends up with an asset worth $225,000.
Which leads me to another question, which is not today. I mean, today, let's face it, that asset's not worth $225,000.
Well, according to what we have in this record.
I understand, but that leads me to this issue, which is if the law becomes that when you... if the law becomes in the state of Florida that by purchasing a home before someone purchases a home before the marriage, you marry that person. Okay, that person already owns that home. They've chosen that home. They put their deposit down. They're paying the mortgage. They marry you. You marry them. The market drops, and there's depreciation. Are we going to saddle the new spouse with the depreciation because we also want to give them the appreciation? Right. It only addresses appreciation, but when we're talking about the equities, I think that sort of points out that the statute is not meant to give the new spouse necessarily the wisdom of the spouse who's made the purchase because they think it's a good investment. This guy, the only reason, and I think it's important to think about the equities in this case because equities are different in every case. Equities are very fact-specific. I think it's very difficult to come up with a rule where you can say it's perfect in every case. And the simple rule that has been, that appears to me to be mandated by the statute, has been applied by the second, has been applied in every district in one or more cases, I think makes it simpler and easier. When you start thinking about the equities, you think, why do you say this person, male or female, comes into the marriage with something that they chose? They chose it because they thought it was a good investment. Turns out the market goes up or the market goes down, and they get that benefit or detriment. I mean, if there's depreciation, they're going to be stuck with it, right? I mean, right now, you come into a marriage with property, if the market keeps going down.
But this was the marital residence for 27 years, right?
Right.
And he acquired the property 6 months before they were married, right?
Right.
And he put $2,000 down.
Mm-hmm.
So, and there were several mortgages during the marriage that she joined in on, which enhanced the value of the property, I would assume. She signed on the note. I mean, she signed on the mortgage. I don't think she signed on the note. But she had to sign the mortgage.
Yeah,
else she
probably
couldn't have gotten the house.
Right.
The mortgage company wouldn't have lent the money.
Right.
So, was that not part and parcel of the enhancement of the value of the house?
The evidence was, and I think the case law that applies the statute this way makes clear that there's a difference between appreciation caused by the market and appreciation caused by the parties. And I don't want to leave here without saying something. No unequal distribution was raised at trial in this case, so there wasn't a whole lot of information put on about the equities. But if you look at the facts, you will see that the equities in this case even suggest that this is not the unreasonable result that many people seem to think it is.
What are the equities that you're talking about?
This man was a little over 30, and she was in her early 20s when they married. The reason he came in with a little something was because he was a little bit older. That's the only reason. These are people of modest means. He's a meat cutter.
They had 4 children.
Right. They had
together.
Right. And he
who I assume all grew up in this house.
Yes. And he's a meat cutter. She works at the school system. She's developing retirement. He comes out of this marriage. Now he's 62. He's in poor health. The record reflects this. Again, we didn't put on an equitable case. It wasn't necessary. The law on the second was clear. But he came out of this marriage in very poor health with strokes. He has little to no, I don't even know if he's working at this point, but little to no working life left. She is continuing to develop her retirement because she's significantly younger than he is. These are people of very modest means. And as the equities are different in every case. The equities are very fact-specific.
But those kind of factors may well play into how the marital assets would be divided. But I don't see what that has to do at all with determining the value of the marital asset.
And I would agree. I think the statute is very clear. There are cases in every district that interpret it the way the second has,
and cases that go the other way too.
But not in every. In the third, for instance, the cases are consistent. Most of the districts, at some point or other, cite back to Straley, which is the case cited by Mitchell. The third cites it. I think the fifth has cited it, and the statute itself is clear, and the statute does give the court the opportunity, if the equities require, to adjust it based on the factors listed at the beginning part of the statute, the unequal distribution. Thank you.
All right. Rebuttal?
Your Honor, if I have part of that minute left, just 3 things. If you consider it this way, what other asset, if you come into a marriage and one party owns a non-marital asset, you invest all the consideration to pay for that into the non-marital asset. Why, and yet the party that came in with little or no equity ends up with all the appreciation. If it wasn't for a parcel of real estate in the second DCA, there's no other asset in Florida that law would apply to. So why would you treat real estate second DCA differently? You make all this investment, and yet there's a cap, a bar to any consideration of the appreciation in value. If this was a bank account and we put $50,000 into it, and in 20 years it became worth $300,000, why, because it's a house instead of a bank account, should the appreciation be considered differently? There's really no policy reason. Second, Straley. Again, the Stevens case talks very briefly about you're limited to the pay down.
Could you tell me about those bank accounts that go from $50,000 up to $300 with no effort?
I actually had a client once come in who had $380,000 in an IRA, and I said, no, it's not an IRA. She said, yeah, it's an IRA. And I looked, yeah, good investments. Mitchell, with a very short non-policy statement about limitation, relied on Straley, which was a sharply divided opinion with many dissenting opinions that were kind of in our favor, more like Stevens. So even the second DCA in the old days, when they considered these issues, struggled with the policy. And finally, just the facts about the husband's health and so forth, that's really for this trial court to determine when we go back on fees. It's not before the court.
Thank you very much. Thank you both for your arguments here today. The court will now take its morning recess for 10 minutes. Next case on the court's agenda is Atkinson versus Walmart Stores.
Good morning, Your Honor. My name is Mike Myers. I'm here with Major Harding, Jason Gonzalez, and Rick Figlio, and we represent the appellants. The heart of the issue certified by the 11th Circuit is really whether the estates of these deceased Walmart employees have standing to bring their case, or whether Walmart is correct that only insurance companies have standing to bring a lawsuit on the topic of insurable interest.
Well, isn't it? Okay, so the law, before the statute, the Walmart had these policies. The insureds were your clients, and they were, the insurance company was who?
AIG.
Okay, and and they wrote these policies knowing some of these people were key people, but they wrote them.
I would disagree with you there, but
well, I thought
please.
there was something about that. But the bottom line is, at the point of death, when the money is paid out to Walmart, what could have happened at the point that the insurance company was going to pay out the money?
I don't know if I follow your question.
Okay,
but
they look at the beneficiary, which is Walmart.
Right.
And they'd say, Walmart lacks an insurable interest.
Right. True.
They would then offer to return the premium and void the policy. Under what theory, before this statute, could the person who says that they should have been the beneficiary make a claim that against the person who's receiving the proceeds?
Prior to the time of death?
No, at the time of death, prior to the statute.
Of death, Your Honor, the estate had a claim. Traditionally, at common law, the way this is recognized is the beneficiary the named beneficiary, if it lacks an insurable interest in the life of the insured person, suffers no loss when the person dies. The estate of that person suffers the loss because the person dies. The named beneficiary suffers no loss, so it takes the policy benefits as a windfall. So at common law...
But they're paid the premiums.
Well, of course they're paying the premiums. If the employees were paying the premiums, it'd be a different case.
At common law, are you saying that the beneficiary could sue the insurance company and the policy owner for the benefits that they say they should have gotten out of this policy that they didn't pay the premium for and didn't assert anything?
We may be misunderstanding each other, so let me answer it this way. At common law, since the named beneficiary has no insurable interest and suffers no loss, the estate of the insured person gets the policy benefits. The named beneficiary, because it's paid the premium, gets a claim in equity for a return of its premium. The insurance and Walmart has made that claim here in this litigation. Now, the insurance company is still obligated to pay because it accepted the premium and the risk. Now, your question of what could have happened, well, AIG could have put the money in the registry of the court and said, we doubt the insurable interest, you guys fight it out. And if there is no insurable interest, then the estate will probably win and Walmart can exercise its equitable counterclaim for the premiums it paid.
You're saying that the insurance policy that the proceeds could have been paid before this statute to the insured?
To Walmart or to the insured person?
The insured person.
I think it would be unlikely that AIG would just pay it directly, but what AIG could do is tender it into the registry of the court and then recognize. Here AIG questioned the existence of the insurable interest before it wrote the policies. What AIG could have done, but did not, is put the money into the registry of the court and it's discharged from its obligation under the contract.
Why is the cause of action against AIG? I'm a little at loss here because you've got statutes telling insurance companies that you cannot provide life insurance, even before the statute, to individuals who do not have an insurable interest in the life of the insured.
Right. Well,
and so if they pay contrary to that, why are they not susceptible to payment according to the law? Well, I mean, it seems to me that this is a clear case of an insurance company marketing a product, getting people to pay them money, and then, whoa, no big deal.
Well, Your Honor, I guess that case could lie, but there are also cases such as a case called De Leon versus certain underwriters at Lloyd's London. This is a Texas Fifth Circuit opinion where the court held insurance company only has to pay once. It wrote the contract. It only satisfies the agreement when it pays.
I think Florida law may be different, that if an insurance company pays contrary to Florida law, they may end up paying twice.
Well, they may pay twice, but, Your Honor, the situation here is that Walmart's got the money. AIG paid the money to Walmart.
But if they paid it wrongfully, why would you not look to AIG?
Well, that's perhaps a good idea, Your Honor. We look
I've seen
to Walmart
insurance companies in Florida pay twice when they've done something contrary to the law. Courts have said, no, this is who you should have paid the money to. You did not do it, therefore they have a cause of action.
Well, Your Honor, like I said, historically at common law, and we do not have the Florida case directly on this point. We have Florida cases where non-insurers have filed suit on this, and the courts have declared there is an insurable interest, so the policy.
Well, but let me ask you this. Isn't there a law which supports the proposition that a life insurance policy issued to someone to a beneficiary that has no insurable interest in the life of the insured is void?
Good question, Your Honor. Let's talk.
Well, let me spin that out, because if it's null and void, then why wouldn't we go back to where Justice Periente started? That's better off the premium, no benefits are paid, the premiums are returned. We go back because the policy never should have been issued. If it's illegal, then how are you going to actually require that the policy be performed by paying anybody?
Well, Your Honor, that's a good question. And on the facts of this case, which is what we're here on, the money has been paid. So when you say you want to void the policy, I don't understand how that can happen as a practical matter. Here the money was paid a long time ago.
Well, it seems that there's an issue about time. I mean, no one's raised that because we're talking about whether the statute's retroactive. But wouldn't the time have been to raise any concerns about who got the policy proceeds, be at the time of death?
Your Honor, the two things. First, that issue will come up because Walmart has raised a limitations defense. Second, if this case is remanded, we'll go over that. And our argument is going to be that this was fraudulently concealed because Walmart said to its employees when it sent out its flyer the money would go to the profit-sharing plan. It didn't. Walmart decided to keep the money. So if this case goes back down to the district court, we may have a fight over statute of limitations. It's not before this court today, but that's going to be our position. The estate has suffered two losses here. Number one, the person died. Life insurance is to indemnify against that loss.
Well,
second, the money was supposed to go to the profit-sharing plan and didn't.
If there's a claim for fraud and misrepresentation, that's different than what we're talking about. We're talking about whether this statute, which came into effect after the death of the plaintiffs in this case, can be applied retroactively.
Right, Your Honor. So
now
I agree. We're not talking about a fraud case. We're talking about fraudulent concealment as a defense to limitations. But let's get to your point. Can this be applied retroactively?
No, I think maybe we stay with the point of what was the law
about
before
voiding the agreement. Okay. If you say that the remedy is to void the policy, it doesn't work here because the contract's already been fully performed. And if you say that the remedy is to void the policy, it's going to take an active participation by AIG or Walmart. That demonstrates how bad the rule would be. Because here, AIG and Walmart entered into this agreement with AIG questioning the existence of an insurable interest from the outset.
What was the rule at that point in time? Not whether it's a good or bad rule, but what was it?
At that time, Your Honor, there had been several non-insurers that had filed suit in Florida courts. Florida courts had adjudicated them all the way to a decision on the merits, including this court. No Florida court had ever said, stop, go away, the courthouse is closed because you're not an insurance company. And several Florida courts had self-identified a duty to take away benefits from Walmart.
Cases, some talked about key man insurance, which we all know is good, and they talked about whether or not a wife could insure a divorced husband up to, but he was still alive. So he could assert whatever. I mean, but that had really nothing to do with whether this 2008 law was retroactive to 2000.
Well, Your Honor, the question, I believe, is if this is remedial legislation, can it be applied to an existing suit? And this court in Smiley versus State in 2007 held yes. So the question becomes, is this remedial legislation? Did it add anything new to what existed prior to 2008? And the answer to that is no. Several Florida courts had entertained insurable interest cases. In one instance, the person was still alive. In other instances, this court ruled on what you're calling key man policies. The question there is...
But the question really is not whether they had entertained them, but whether or not it's... You are basically arguing, as I understand it, that this statute really just codified existing law.
Yes, Your Honor.
And so what are the cases prior to this one that said that the estate or of the person who was the named person on the policy could recover the proceeds?
Your Honor, we don't have this exact factual situation because the Florida Supreme Court cases were key man policies. But I would ask you, what would happen, let's say, in McMullen versus St. Lucie Bank, where the bank was allowed to keep the money because the insured person was an important bank executive? What if he would have been the janitor? I mean, would the result have been, I know you've been through several years of litigation, but ha-ha, joke's on you. We can't give you a judgment to enforce our rulings.
If this was such clear law, even prior to this statute, my question then becomes, why? The deaths in this case occurred in 96 and 97?
Yes, Your Honor.
And then we have this filed in 2008.
Yes,
correct?
Your Honor.
So if it was so clear, why wasn't something filed at the time that the monies were actually paid?
Walmart was telling people it was being contributed to the profit-sharing plan. It wasn't. Walmart kept the money. When these people found out Walmart kept the money, they filed this suit.
But now the whole issue here of whether Walmart did something wrong and not contributing to the profit-sharing plans is a rather different issue. I mean, obviously, your clients, the harm that would have come to your clients from that would be a very different sort of harm than what you're alleging here, wouldn't it?
I don't know, Your Honor. The argument would be...
The measure of damages would certainly be different, wouldn't it?
I think the question in this context would be, does Walmart Stores, Inc. Corporation profit-sharing plan have an insurable interest under these circumstances? I don't know. Does Walmart Stores, Inc. have an insurable interest in the life of its rank-and-file employees? No.
But this whole pension thing's not part of this case, is it?
Well, it's our response to their defensive argument of limitations.
Okay, but I mean as far as what the federal court is trying to get us to answer. I mean,
No,
this
no,
seems
Your
like
Honor.
we're talking about two different things. I mean, it seems to me you have a very appealing argument on misrepresentation as to what's to go into a pension plan, it doesn't go, and those kinds of things. But as I understood the question before us, it's just really looking at this statute.
I agree. I'm hearing a lot of questions about the timeliness. The people brought the suit when they found out where the money went. And so they've got a defensive, Walmart has the defensive limitations. We've got a response. But the question we're here on today is, can this statute be applied to this case? Is it even necessary to apply the statute to the case?
Because we're talking about pension plans, it doesn't seem like this statute necessarily even really has anything to do with it.
It does not. That is only in response to the defensive argument of limitations. The issue is whether the estates could have sued Walmart for this money prior to 2008. Yes or no? I believe or whether only insurance companies had the right to go to a Florida court and say, no insurable interest. Here, the money was paid. The parties fully, Walmart and AIG, performed their illegal contract.
It doesn't, I mean, in fact, the insurance company has a duty, now recognized but before, not to pay out insurance proceeds if someone lacks an insurable interest, because the reason for the whole policy of why there would be needs to be insurable interest is to prevent the possibility of harm coming from, because somebody has an interest in the insured's demise, someone who doesn't have an insurable interest, correct? I mean, that's the...
That's the public policy, and to avoid gambling, illegal wagering agreements.
So what I'm still, I guess, struggling with is this idea that the policy should have been void at the point that AIG made a decision to pay out
Correct.
money. And if the objection really should have been that AIG, should have return the premium. And that would have been the appropriate way for AIG to have gone.
Well, Your Honor, AIG didn't go that way. AIG and Walmart had an agreement to do an illegal act in the state of Florida. When you and Justice Kennedy, I'm sorry, I keep getting off the answer to your question. If the policy is void, it can't happen. They've already performed the contract. If voiding the policy means leaving the parties where they lie, they've successfully thwarted Florida public policy and broken its law. If voiding the policy means returning premiums, that is really an action for contract rescission. And who's going to file that suit? Here, if you have parties satisfied with their illegal agreement, like you have with Walmart and AIG, this notion of voiding the policy doesn't work as a practical mechanism.
And that's why I guess the statute was put into effect, because they realized that this legislature realized that this could create a problem. And now there is, at least prospectively, a substantive right both to give your clients standing and to put response and to be able to sue Walmart. I think we're just really dealing with the fact of whether that statute can be applied retroactively.
Right.
And it's not questioning, it seems like a very good policy, public policy the legislature has enacted, but I'm still, and I understand how you're extrapolating that Florida law might have been there, but I'm still having trouble to see that it actually was there.
Your Honor, I'm going to reserve my time for rebuttal and to answer your question. The estates had standing to sue, just like these other estates did in the other cases. Whether they were executive officers shouldn't change that outcome. The difference in McMullen versus St. Lucie Bank shouldn't be different because a janitor sued instead of the estate of a bank executive. The answer should not be, no, the courthouse is closed to you, janitor, but it is open to the bank executive, and we'll adjudicate that estate's claims all the way to the Supreme Court. So that would be my response, that the estates always had standing to sue, just like the others did, and I'll save my last 2 minutes and 46 seconds for rebuttal.
Good morning, Your Honors. May it please the Court. My name is Eileen Moss, and with me is one of my partners, Dan Rogers. We're here on behalf of the appellee, Walmart. I wanted to first just go back and address Mr. Meyer's last statements. It's clear under Florida law that the estates had no standing prior to the July 1st, 2008 legislative amendments to sue. There was no legally cognizable cause of action that existed for insureds or insureds representatives to sue a beneficiary who had obtained insurance proceeds.
So what are the cases that he relies on that say that there has been adjudication of those disputes?
Mr. Myers relies on?
Yes.
None of those cases at all hold that there is a cause of action, a common law cause of action to recover. They are issues that are completely inapposite to this. The cases that they rely on do not directly create a cause of action, and this Court well knows the language that would need to be stated in those cases. I can go through, and we did distinguish those cases for Your Honors in our brief. Would you like me to address each one of those?
No, I think just take the one that went up to the Supreme Court, to our court.
Well, the one case that does address what the remedy is the Knott versus State on behalf of the Guarantee Life Insurance Company. And that was a case that recognized it was actually with an insurance, Department of Insurance Commissioner, where there was a certificate of insurance that had been issued, and the insurance commissioner wanted to strike the paragraph that said that, you know, you have to have an insurable interest. And this Court recognized and relied upon the statute that's on the books prior to July 1st, which we as the state of Florida incorporated through Section 2.01, which is an old English common law statute called 14 George III. And in that statute, which is a statute that was effective and on the books, along with Section 627.404 that had only two other provisions, that was a controlling law. And in Knott versus State XREL on behalf of Guarantee Life Insurance Company, this Supreme Court recognized that the remedy was to null and void the policies. And it was not until July 1st, again, as Your Honors are well aware of, that created a cause of action so that insured or their reps could maintain an action to recover the insurance.
Well, we've always
proceeds.
assumed, or I assumed, that it would be the responsibility of the insurance company. You know, they do underwriting before and then after, and to look after, and when they finally have to pay, and determine before they pay if there's an insurable interest. If, in fact, there is was a situation where, as they've alleged here, it's almost a conspiracy to enter into an illegal contract, why, with those unique facts, where there's no motivation for the AIG to actually refuse to pay because they're getting so much business from Walmart, why wouldn't there be standing on the part of the beneficiary to sue because it's Walmart that lacks the insurable interest?
I think the answer to that question is there's multi-parts to that. First of all, just from a factual standpoint, factually in the record, what occurred here is Walmart and AIG, they established the trust for the insurance trust in the state of Georgia. Georgia permits this exactly the agreement that was reached. So if you go back factually, in their minds, this was not an illegal contract. This was legal according to the laws of Georgia. Now, for purposes of the class certification motion that was before the federal district court in the Middle District of Florida, for purposes of addressing whether or not Florida does in fact have a legally cognizable cause of action for them, we went ahead and conceded for that purpose only that Florida law would apply. So factually, Your Honor, there really wasn't in their mind the mindset that they were entering into intentionally violating Florida law under the real events that occurred. Secondly, with respect to your question as to why can't the insurers go after Walmart, that just simply wasn't the law. The law in the books was, again, George 3rd statute in conjunction with 627.404 that had only two provisions. One provision was an insurance company is entitled to rely on the representations made that one does have an insurable interest. The second provision, and the only provision that existed until July 1st, 2008, was that a charitable organization that complied and met the requirements of tax code could also set up and insure without an insurable interest the lives of another. So I hope that addresses the questions that you...
This whole thing about the trust and the pension and all that, that doesn't seem to really, from what we've been presented in briefing and arguments, I mean, to be really part of this discussion. When why is it not? It
should not be part of the discussion.
Why
the
not?
question before Your Honor,
I understand what the question is, but I mean, to me, it seems like we're answering some questions that if there is a valid trust, there's some kind of valid agreement that I haven't seen. Is there an agreement that's been given to us that I haven't seen?
It's not part of this record, Your
Right.
Honor.
I mean, so I'm hearing things this morning that to me seem related to what we're talking about, and whether someone has violated the terms of a pension trust agreement or something like that is a totally different issue than just a beneficiary having a cause of action. And so, I mean, but at the same time, I don't know whether there are any rules or regulations or laws that would permit a pension trust from purchasing or doing something different than just a straight employer. You understand what I'm saying?
I do, Your Honor.
And this is muddling everything in my mind as to what we're even talking about today.
Then I'll redirect our focus to what the question is, and that is whether or not what the question that was certified is May 627.404, the amendments to that statute effective July 1st, 08, be applied retroactively to the pending case. And the answer to that question is, without a doubt, absolutely not. And the reason is because a statute that first of all, there's presumption against retroactivity when a statute creates new substantive rights or imposes new legal burdens. That's the Arrow Air case. Chase, Your Honors, addressed this topic in Menendez recently, just last month. This statute is absolutely a substantive statute. It creates a new cause of action, just like the Arrow Air versus Walsh case did. My opponents argue that this is a remedial statute.
Actually, the legislature said it was clarifying the law, but we can't rely on that statement unless there was law that needed to
That's correctly, absolutely correct, Your Honor. I agree with you.
You just before, you're making very knowledgeable about the case. In our certified questions, it presumes that the party receiving the benefit lacked an insurable interest.
Correct.
Has that already been conceded, that some of these weren't key man policies?
For purposes of the briefing, yes, Your Honor, it was conceded. So,
to go back to whether this is a substantive or procedural statute, it seems to me their argument is that this is, and I guess that statement by the legislature really is that this sort of existed prior to this cause of action. And so if that is the case, then why isn't it really just a procedural statute?
First, to go back on a couple principles. Number one, this court itself has recognized is even if one could somehow classify the statute as remedial, this court itself has recognized that it's, and it said this explicitly in an arrow air, that it never intended, the court has never classified a statute that accomplished a remedial purpose by creating new substantive rights or imposing new legal burdens as the type of remedial legislation that should be presumptively applied in pending cases. So this remedial substantive distinction, if it is creating new substantive rights, as it is here, it's a new cause of action, the presumption against retroactivity applies, and we must go to clear legislative intent. It must be clear evidence of legislative intent, which leads to the point of the law, Justice Quince, that they are relying on. So you look to the terms of the statute and you look to the purpose. The terms that they're hanging on is clarify existing law. In no way does that, in any sense, provide the kind of clear evidence of intent that a statute should be applied retroactively. Beyond that, and this statute, by its terms, did not say this act shall apply retroactively to cases pending before July 1st, 2008. Instead, it said this act shall be effective as of July 1st, 2008.
Well, even if it were to apply, then you go to the second prong as to whether there's any violation of due process. Now, is Walmart claiming that they had a settled expectation that they could keep what could be characterized, if they didn't have an insurable interest, as illegal benefits?
As this court enunciated in Menendez, if the central focus and essential inquiry as to constitutionality of retroactive application is whether or not it created new legal consequences. And yes, our argument is, so did it impose new burdens, did it impose new consequences? It absolutely did. It created a new cause of action, it exposes them, and there's settled expectations that had passed. It's akin to, we cite in our briefs, a statute of limitations case where a conduct that had been considered to be a violation of the law, it gets settled, not settled, pardon me, but then time passes, no one sues, there's a settled expectation that that's what it is. Here in this case, and the court recognizes, you look to the law that was in place at the time that the contract was entered. Here, the sole remedy was null and void. And as this court has recognized, those issues of perhaps what someone may seem to feel that it's unfair, why should they keep the proceeds? And I do want to make clear for the record, there was no profit here, and that is in the record. They lost tens of millions of dollars. There's an affidavit. That's the evidence before this court. So to say that there's a profit,
what do you mean they lost tens of millions of dollars?
Out of this program with the IRS, because the program was set up for tax benefits. But going back, there's just clearly no clear legislative history. And to clarify, if you look to the legislative history on this clarify existing law language, Justice Quince, it's very clear. We've provided Your Honors with the legislative history through the sponsors of the bills to both the House of Representatives, the sponsor of the bill to the Senate, the staff analysis, and the white paper that was written by the committee. It was actually a trust and estate planning committee of the Real Property Trust and Law section of the Florida Bar. But you'll notice that throughout all those statements, the entire legislative history, what they were clarifying was whether or not, and how do you determine whether or not an insurable interest exists. They were not clarifying to say, gee, the courts are all messed up here. The law doesn't know. Do you have a cause of action or don't you have a cause of action? That's not what they were clarifying. Time and time again, the language is clear. It was to clarify whether or not an insurable interest existed. And what was propelled by a decision out of the Eastern District of Virginia, a 2005 called Cha Law, and we point Your Honors to that case in our briefing and discuss it. But the estate planners and insurance professionals needed guidance because they were used to being able to put into trust and irrevocable trust life insurance proceeds, and this case threw everything topsy-turvy. So, and again, we cite to those papers in our brief, but that was the impetus for this. That section is what actually prompted the amendments to this. So the clarify existing language is not that we need to clarify whether or not. The law was clear. You can scour the law. There's no case. There's no statute. And the legislature and the Florida law at that point had decided to circumscribe the remedy to being null and void.
But we don't have an actual case that said they lacks that the beneficiary, the insured's beneficiaries lacked standing. Do we have that case in Florida? We might say that the remedy was null and void, but do we have a case which actually specifically says that they lack standing?
We have neither one. We have no case where the issue arose and framed, does an insured or its representative have a cause of action to maintain. And in fact, as again, the remedy under Florida law was simply to null and void, as recognized in the 1939 Knott case and the statute that was on the books.
Now, it seems to me there are some cases that were cited, I guess, that where an estate actually filed actions about whether or not there was an insurable interest. And I know one of them involved a key man and one involved a bank president or something. And so how are those cases distinguishable from this situation?
Well, those cases definitely only were dealing with whether the different ones I could walk through. McMullen, which is one, it clearly doesn't, again, none of these cases go the step to say that you have a cause of action. The court in McMullen, it was an issue about heirs and whether they had a remedy for the alleged lack of insurable interest. It was dealing with the president, and he had assigned his policy to the bank. And in that case, they sought to recover the heirs of the president of the bank, sought to recover the proceeds that they had received from the policies that were insuring the president's life. What was decided is they agreed that the bank procured the policies and that they were entitled to keep it.
Well, I guess, although the cases don't actually talk about whether there's a cause of action, it seems to me that something was adjudicated in those cases, and so I'm not sure that the cases have to say there is a cause of action. I mean, in one of them, it seems to me they said that the partnership, or I believe it was entitled to the $1,000 policy, and the other, so the cases were actually adjudicated. So that's my issue here is, even though it doesn't say there is a specific cause of action, the case was decided.
Decided, but they're not the issue that's before this court, and that is whether or not the Florida law did not recognize such a cause of action, and it didn't recognize it until July 1st of 2008. And it's under the clear legislative history, and there's no clear legislative intent that be applied retroactively.
I would expect that law, not seeing the case, but if somebody has an insurance policy on someone that there's no insurance interest on, I would expect that person to be able to go into court and seek some type of declaratory action that policy really is void.
I don't necessarily disagree with that, Your Honor.
And that statute would have no application to
that
scenario.
Correct. That's one issue of standing. Standing to declare it void, that's not what this action is about.
Right. The difference between standing to seek some type of adjudication as to whether there's insurable interest and standing to seek recovery of benefits under a policy.
Correct. Absolutely, Your Honor.
So if they simply wanted to declare that these policies were void, they would have standing?
The majority of the states, Florida has not decided that issue. Now, I will agree that there are cases that would seem to indicate that. The statute is not clear, and it is correct that in the majority of the United States common law, with the exception of 2 states, there is no standing. They've held there was no standing. And it was, I think, frankly, there was one like 1890 case out of Michigan, Smith versus Pinch. It's cited in our briefs. I think it's based because on contract principles. that the parties, you have to have standing. They were not parties to the contract, and they weren't harmed by it. They didn't pay the premiums, and so the decision was made, no standing. Now, where they started creating standing was through statutory rights. And in Florida, we don't directly address that. But again, this issue of standing is a double-layered question. And what we're saying is they don't have standing to maintain. There is no legally cognizable cause of action in Florida that permits them until July 1st of 2008 that permits an insured or its reps to go back and claw back insurance proceeds. And that the wisdom and the propriety of that circumscribed remedy has existed in this state for quite a few years.
Going back just to McMullen, and I don't have the case in front of me. I have Walmart's discussion of what it said. McMullen recognized an insured's error standing to raise the beneficiary's lack of an insurable interest. You say that's incorrect, but that the heirs of the bank president sought to recover the proceeds the bank received from policies insuring the president's life. Okay. There wasn't a motion to dismiss for lack of standing, correct? What happened was instead the determination was that the bank did have an insurable interest. Going back to, isn't the implication that the cause of action, if they couldn't, that they would have had, if the bank didn't have an insurable interest, they would have been able to recover the proceeds?
I disagree, Your Honor.
Well, you disagree? Yeah. That's the implication. I mean, otherwise they would say that the beneficiaries had no standing to raise this issue to begin with.
The remedy as permitted under the legislature is to void the policies as null and void.
But that's not what the heirs were seeking. They were seeking benefits paid to the bank. I mean, I had limited. I would have agreed with you that I thought the only remedy was to be able to void a policy, but I don't think McMullen can be dispensed with as simply in terms of that this court was saying, certainly didn't say they didn't have standing, and certainly didn't say that they wouldn't have that cause of action. You wouldn't adjudicate the dispute if those threshold two findings were contrary.
Well, the court my reading and our reading of McMullen is that it didn't address the issue as to whether or not the heirs did have standing to actually recover the proceeds.
Because they found there was insurable interest.
Correct. So because it was a key man policy.
There are different ways you can consider those issues, and they went down one track instead of going down the other track, which is maybe more logical, but it doesn't necessarily decide that question.
Correct, Your Honor. That's correct. And it was a key man insurance policy, so that's why it was the president of a bank, so they found that there was in fact an insurable interest. I see my time is running out unless any justice have any other questions. And with that, I appreciate your time and would urge that you answer the certified question that no, Section 627.405 shall not be applied retroactively. And yes, it did create a new cause of action such that the insureds or their reps were not entitled to maintain a cause of action for insurance proceeds received prior to July 1st, 2008. Thank you very much.
With my rebuttal, let's stay on the topic of void. Void does not mean the appellants lose. There's a case involving these same policies on Walmart's Texas rank and file employees. It's Mayo versus Hartford Life Insurance, 354 Fed 3rd 400. The federal district court finds and the Fifth Circuit affirms the policies are void because Walmart has no insurable interest. But the plaintiffs still win. In this state, there is a case involving property insurance called Phoenix Insurance Company versus Hilliard. The policy on its face is void because the named beneficiary isn't the exclusive owner of the property.
Well, let me ask this question. If you don't need to rely on the statute,
right?
Why didn't you include a separate cause of action, a common law cause of action under, did you?
Your Honor, that's our only case. Our case is for a declaration of rights that Walmart has
What's your only case? Is it under the statute?
No, Your Honor. We filed the suit before the statute was enacted.
So has there been a determination that there is no has someone made a determination there's no common law cause of action?
The federal district court judge, when he sua sponte, threw the case out.
But that wasn't certified to us.
Well, that was
The only question certified to us is whether the statute can be retroactively applied.
But that depends on whether it's remedial, and that depends on whether these states have standing to sue.
But if the issue is that there's a separate common law cause of action that's just never been rejected, it just never was enunciated, wouldn't the correct question also certify? Wouldn't you want to ask us to certify?
Well,
did a cause of action for a common law cause of action to recover benefits exist prior to that date?
Your Honor, I think that issue is fairly before this court, because the second part of the question certified asked whether the statute created a new cause of action such that the family would lack standing to sue for benefits obtained prior to the enactment of the amendments. So the question certified to you asks expressly, could you sue before the statute? And the answer is yes, but
the answer is we never decided it.
Well, Your Honor, in Mayo versus Hartford Life Insurance, just because it's void doesn't mean the plaintiffs lose. In fact, they win. In Phoenix Insurance Company versus Hilliard in Florida, the contract's void, but this court holds insurance company still has to pay the party with the interest. So appellants still win even if the policy is void. This case is McMullen. This is McMullen. The only difference is that was the estate of a key person who sued. Here we have the estate of rank and file employees. If these insureds have standing to sue, then this seamless web of the law works perfectly. McMullen was correct. Gerstel was correct. List versus List with the living person was correct. The legislature was correct when it said it was only clarifying the existing law. The dictionary definition of clarify is just to make clear, easy to understand, doesn't add anything. This seamless web of the law is seamless. Public policy is promoted. If only the insurance company has standing to sue, the insurance company is delegated with the obligation of enforcing public policy. This court got it wrong in McMullen because there should have been a dismissal on standing. This court got it wrong in Gerstel. This court, the 4th District, got it wrong in Liss. The legislature got it wrong when it said it was clarifying existing law, because if only insurance companies have standing to sue, it created a sea change in the law. So on one hand, we have everything fitting perfectly together if the estates have standing, and on the other hand, we have a machine where the parts are flying to pieces because everybody's wrong. Thank you.
All right. Thank you both for your arguments.
We're going to be calling the next case. Justice Quince is recused on that case. The next case is Kilgore versus State.
Yes. Oh.
Okay. All right. Parties ready to proceed? All right. And again, I just want to reiterate Justice Quince is recused on this case. So, Mr. Hennis, you may begin.
Thank you. I'm William Hennis from the Capital Collateral Regional Counsel Office in Fort Lauderdale for Mr. Kilgore. Just briefly, I'd like to recount that this case does have a somewhat convoluted history before this court. The direct appeal was heard back in 1996. with Justice Kogan dissenting, believing that the case should be sent back on remand and Mr. Kilgore should be resentenced to life.
Has this been in post-conviction for 12 years?
Yes, Your Honor. Part of the reason for that is because of the Atkins opinion and the mental retardation litigation that went on in post-conviction in the midst of the evidentiary hearing. And, of course, there was also another issue in which we litigated whether or not CCRC South was able to challenge and investigate the prior violent felony after we received what we believed was some Brady information during the post-conviction records process. So that's briefly the history of the case before this court. I'd like to point out just in beginning that Dr. Henry D., who was an expert both at trial and in post-conviction as a psychologist, he's now deceased, but he said in his post-conviction testimony, and he's testified before circuit courts in a lot of the capital cases that y'all have heard, that this was the worst case of dire economic and cultural deprivation he had ever seen.
But that's not the issue. The issue is the question is whether that was presented before, and he's, of course, is a mental health kind of guy. So, I mean, there's no question in this case, and I think that you don't need to beat the drum much on that. This is probably one of the worst. But the question is with regard to is there ineffective assistance with the manner in which it's presented, and primarily it seems to me the information about the Oakley Training Center or whatever was probably the biggest deficiency. But how does that lead us to a reversal here? We all understand. I mean, this really is a very deprived, and I think that's very clear from the face of things. But you do understand that's not really the issue.
I think the case comes down to where is the prejudice here.
Okay.
You know, it's the state's position is basically that the evidence that was presented was cumulative and that it didn't make any difference, particularly in a situation where the trial court found both statutory mental health mitigators and some non-statutory mitigation. Right. Obviously, our position is that the jury needed to hear that information about Mississippi. They needed to hear about what happened in Oakley Training School in the late 1950s and early 1960s.
The jury did hear about the moonshine and the alcohol use and that kind of thing.
They heard about it third hand, and primarily they heard it from Dr. D. based on self-report by Mr. Kilgore.
Well, I mean, they heard
just days before the trial took place.
The evidence was presented to them.
Some evidence in mitigation was presented, enough evidence for the trial court to find both mental health mitigators, however, giving them essentially no weight whatsoever. In fact, mentioning in the context of his sentencing order, and I think I should read this, that concerning the mitigating circumstances, I found that both statutory mental health circumstances were proved during the penalty phase. Nevertheless, there's little or nothing about the facts of this case from which one can conclude that at the time of the murder or during the 24 hours preceding the murder, Mr. Kilgore was under the influence of extreme mental or emotional disturbance. And as to the other mental health mitigator, he doesn't really even mention it except in passing. He doesn't even make that same kind of comparison. That's what the jury needed to hear. The jury needed to hear Dr. Dudley's testimony about how the 1978 murder and the murder in this case were essentially the same event. They were an event that was based on those two statutory mental health mitigators and Mr. Kilgore's circumstances at the time of the two different murders. They needed to hear from Dr. D after he reviewed all the background material, after he got the information from the sociologist Mississippi expert, exactly what his basis for his opinion was, and that's what he couldn't provide.
But Dr. D said that even after hearing all of that, obtaining all that other information, that his basic diagnosis and opinion does not change.
Fair enough, but that diagnosis and opinion weren't communicated to the jury with the depth and breadth that needed to be communicated.
So that's really what we're back on. We're back on the case of that I guess now Judge Alcott should have presented more.
Absolutely. I mean, look at what Judge Alcott didn't do. I mean, he didn't hire an investigator. He said he relied on...
but again, I mean, it's almost so what? Because this happened in prison, and what are you going to investigate further? I mean, that's the strategy. So I think you really need to get to the heart of what the concerns are here rather than some of those.
Well, the state's position was that there was no reason to investigate in Mississippi based on the remote possibility that we might find somebody who knew Mr. Kilgore 30 years ago. That wasn't what we were trying to do. The reason we did such a massive investigation in Mississippi was because that was the key deficiency in the presentation at trial.
And you found no school records that you'd be looking for. You found no records of any significance. You may have found a few more relatives, that kind of thing, correct?
Well, I think actually the most significant thing we found were the juvenile court records, which I had
to relate to Oakley.
I had to go in and handwrite, because they wouldn't provide them to me, explaining the context of his juvenile admission to Oakley in segregation times. That's a story that the jury needed to hear about.
All right, let me ask you about Oakley, because Justice Lewis said obviously that wasn't presented. It sounds like Oakley was a terrible place. How long was Mr. Kilgore in Oakley?
I believe it was about 4 years, 3.5 or 4 years.
And did you have his records during the time he was at Oakley? In other words, I guess there was a testimony about what a terrible place Oakley was, but wouldn't you still have to relate that to how it would have affected Mr. Kilgore in his formative years?
Yes, and I think that to some extent we certainly tried to do that by putting on the testimony of the inmate who was in Oakley with him at the same time, who was also for a time on death row in Florida, and he got off death row because he was mentally retarded. And he testified about how he was the smarter of the people at Oakley. He always was a better reader than Mr. Kilgore was. Plus, we had the interviews with the staff who worked at Oakley. The records were unavailable. Perhaps, I would suggest, if back in 1994, prior to the trial, Jeff Holmes, or for that matter, Mr. Alcott, had made any attempt whatsoever to go to Mississippi, they would have had more luck at getting those records than we did.
But there's no proof of that, correct? I mean, because we're stuck with it.
Well, Professor Bell did testify that by the time he was looking for records at Oakley, that they had been destroyed. And, of course, that was during the time we were investigating in post-conviction. The records with the federal lawsuit, to some extent, we did provide some opinions, et cetera, as part of our background material. But
I want to ask about the investigation,
sure.
Because this does concern me in terms of any possible deficiency. I mean, even though we can decide it on prejudice, you had the first counsel, Holmes, pled him out, and then there was a penalty phase. Is that correct? An initial penalty phase?
He pled him out basically in front of the judge.
Okay, but then, so there was, right, then did he present any evidence?
Yeah, he presented some of the mental health evidence that's in the record with some of the early evaluations back in that time period, yes.
What did Alcott present that Holmes didn't present? In other words, is your argument, because Alcott actually asked for a second chair, Holmes actually asked for a second chair. Alcott said, I didn't think he needed a second chair. He also, to me, what's so deficient about this performance is that this isn't a situation where in the investigation it was hard to find the relatives. Most of them were living in Lakeland.
Yeah, there were local relatives.
And what was Mr. Alcott's reason that he picked on the two youngest ones, who would have presumably the least knowledge of the childhood, to put them on? Did he speak to the 9 other siblings?
He didn't really have an answer to that question. He said that he relied on the work that Jeff Holmes had done almost entirely, that it was Holmes' investigation, that he relied on Holmes' records, his files, that he essentially didn't talk to anybody else other than to prepare them immediately before the evidentiary hearing.
Did Holmes do an investigation?
Holmes did some investigation.
Well, so that's a different situation, because if somebody else has done the investigation, you don't have to replow the ground. I mean, in other words, is there
Well, you've got to remember what happened in Holmes' case, though. I mean, Holmes' investigation was based on the fact that he believed that if he pled Mr. Kilgore out, that the judge was going to grant a life sentence, no matter what he put on. That's what he testified
But
to.
in terms of cumulativeness, I understand that just because it was touched on, now it's a different, it has more impact. Are you making the allegations that the two siblings who testified really did not
have knowledge as to what they testified to, and that the people that now testified really would have painted the picture that wasn't there before? Because that's where the issue is, whether it's cumulative, and obviously there wasn't a reasonable strategic decision because he didn't talk to the other siblings. So I'm trying to get that flavor for what his rationale was for not talking to the other siblings, and what else did the other siblings have much more in-depth information about his childhood?
Well, what you mentioned before is sort of self-evident. The youngest siblings would be the ones who had the least experience growing up in Mississippi with Mr. Kilgore. They certainly weren't in a position to talk very much about his earliest days. There was one older brother who testified, I believe, who, in post-conviction, who gave a good deal more detail. But I don't think it's just the family testimony that's important about Mississippi. I think that the folks who were part of the background materials that the experts relied on, that is the Oakley employees, the folks in the area around where the family lived.
But see, there you have, again, and I understand you can only work with what you did, but talking about what Oakley was in a vacuum without relating it to him, still, to me, because we got to get to prejudice as to whether, with the aggravators in this case, that this could have been powerful statutory mitigation. And
well, that's the other issue,
not sure
too.
I'm seeing all of the connections being
made. The failure to attack the aggravators is also a serious deficiency on the part of Alcott. He stated in his testimony he didn't even look at the background materials or the stuff about the prior violent felonies. He didn't research them. He didn't look at the PSIs. He didn't even look at the records of the files. He didn't even depose Barbara Ann Jackson before she testified at the penalty phase, and she was probably the key penalty phase witness in support of what the judge found as the most important aggravating factor, which was the 1978 murder, which he described in a short paragraph. That description is completely contrary to the evidence that we put on at the post-conviction hearing and that should have been put on in an investigation about those prior violent felonies.
Was she deposed during the first proceeding?
Yeah, she was not deposed during the first proceeding.
Did she testify during the first proceeding?
She
was
did not.
there a record of her testimony during the first proceeding of some kind?
No, I don't believe she testified at the first proceeding. I don't believe so. In any case, Alcott didn't look at any of the prior depositions, any of her prior testimony. He didn't attempt to impeach her. And, of course, he didn't have access to the Brady material that we got during post-conviction. Our view is that what her testimony, what she could have been impeached about, was that the first shot was by the victim in 1978. That it was a provocation kind of situation. That, in fact, Barbara Ann Jackson was Mr. Kilgore's girlfriend, which she denied both at the trial and in post-conviction.
I'm sorry, I have a problem with your argument because it's my recollection in your brief that you argue that the deficiency is the cross-examination of this witness because the deposition testimony, there was conflict with the trial testimony. So I find it hard to understand your argument. She was never deposed. There's never any testimony when that is what you've argued in your brief.
It was the depot in the 1978 case, Your Honor. That was the depot. She was deposed in 1978 prior to the 1978 trial where she testified.
And the issue was the sexual relationships and whether she had one or didn't have one with them. Is that correct?
That's right.
That's what you've argued in the brief?
That's what was argued in the brief,
and
yes.
Did the state and everyone concede at trial of this sexual relationship?
I'm not sure there was a concession. I think that
Everybody talked about that, yes, that it did. She may have said no, but there was a sexual relationship. If I'm using the wrong word, you tell me what the right word is, that it was discussed, was it not?
There was some discussion, yes. And just before I get completely off the point about the 1978 case, the PSIs for 78 and the parole information that are also part of the record, which Alcott never looked at, clearly indicate that there was a completely different account of what happened at that 1978 event, and it should have been used. It should have been put before the jury. They should have known the whole story, because ultimately what happened is the court relied on that 1978 murder to offset the statutory mitigation that he found. And he didn't really give the statutory mitigation any weight anyway. That's the problem with this case. Mr. Kilgore probably would have been better off if trial counsel hadn't found any statutory mitigation, no matter what was put on, because then he might have actually had a chance to get relief back in 1996. Whereas by the finding of the statutory mitigation without giving it any weight and connecting the statutory mitigation to the fact that it didn't appear to have any effect on the crime, that's the prejudice. The prejudice is the failure to give the statutory mitigation effect by the judge, and the fact that the jury never heard the evidence supporting non-statutory mitigation and bolstering the non-stat myths. That's what the Mississippi evidence would have done. It would have given the jury some reason to find those non-stat myths by their vote. Instead of being 9-3, obviously our view is it would have been 6-6.
You're in your rebuttal, if you want to say it.
Could I ask you just to comment on one? I was disturbed about the voir dire with regard to homosexuality. Would you make your best shot with regard to how that was handled by Mr. Alcott and what he should have done? What's the prejudice?
I think very briefly,
I don't want you to use up all your time.
There was really no attempt to do that at all. He sort of blew it off in our examination of him. Likewise, with the whole idea of using any of the information that was out there about the prison witnesses and how credible they were, he simply disregarded that. He said that's not something that I think that's important. Finally, I would say look to Coney versus State, because it's, as you've said, it's the province of the jury uniquely to sift through the evidence, and that's what needed to happen here. The same expert in Coney also testified in this case, Tom Hyde, and Tom Hyde said, sure, there was a previous neurological, but this guy has got some serious things going on. There needed to be a medical doctor back at trial to say that, so that people who were sitting on the jury would know that this is not just an expert who came in a week before the trial who was spouting off about this.
He had three experts at his trial, didn't he?
He had Dr. D.
No, didn't he have Dr. Kremper?
Dr.
Ainsworth?
Dr. Kremper testified at the
original
Holmes trial. And, in fact, that's who the trial court relied on in part for the second statutory mitigating factor.
And was
Dr. Kremper actually found him to be incompetent to proceed, but that's sort of a different issue.
And there's not evidence of brain damage, organic brain syndrome at the trial?
There was evidence of organic brain syndrome at trial through Dr. D's opinion. It was not really confirmed by anything other than Dr. D's opinion, essentially based on self-report and his substandard waist test. Just briefly about mental retardation, I know in my rebuttal time, but keep in mind that the judge's order on mental retardation in this case relied only on the 3 IQ tests that were given by the defense. He disregarded the other IQ tests. That is the Kremper IQ test of 76, the Eisenstein IQ test of 75, and the D IQ test in 2004 of 74. So that given this court's finding rulings in Jones and Cherry, obviously those IQ scores, those full-scale IQ scores, are over 70.
All right, you're now going to have less than about a minute left. So
if Jones and Cherry aren't good law eventually in the federal courts, then obviously Mr. Kilgore is in a situation where the Mississippi information is of critical importance in finding his adaptive behavior meets the mental retardation criteria. That's another important reason for the Mississippi evidence to be developed. It should have been developed back at trial because Dr. D testified that he was mentally retarded based on his short form WACE IQ score of 67. I'll sit down. I see I have 44 minutes.
May it please this honorable court. Your honors, my name is Catherine Blanco with the Attorney General's Office out of Tampa, representing the state of Florida. Before I begin my argument, I would like to address one misstatement that opposing counsel made with regard to Dr. Kremper not testifying at the 1994 penalty phase. He most certainly did testify, Your Honor. His testimony is in Volume 10 of the 1994 penalty phase, and one of his comments at that penalty phase in 1994 addressed the beatings that the defendant was alleged to have received, and he attributes this to Mr. Kilgore's statement to him. He indicated that he was beaten, I think he said frequently, as a juvenile within reform school. That's at page 1486 of volume 10 of the 1994 record.
Clearly,
So
there was not a real development of the Oakley Training Center. I mean, you'd have to agree with that.
Oh, certainly. We agree that there was no expose on Oakley Training Center.
And would
Absolutely.
you go then, why that certainly, if I'm trying that case, seems to me that that's probably something you really ought to do. But let's go to the prejudice aspect. What was found? What was presented? Could you address that, please?
Certainly, Your Honor. I'd also like to emphasize that what you have here is a defense attorney, very experienced defense attorney at the time, Mr. Alcott, who chose to focus on the defendant's deteriorating mental condition. So that was something that was closer in time, rather than on the defendant's time spent in Oakley 30 years earlier. So what did we have presented?
Let's say, how could he have chose to focus on the deteriorating mental condition over Oakley if he didn't know about Oakley?
He knew about the defendant being institutionalized at Oakley from 1962 to 1965. He talked about it with Dr. D, about the deplorable conditions. He knew that the defendant had been in a training school when he was 12 to 15.
What would be his reason for not pursuing that? Just to I mean, it's 3 or 4 years out of someone's life in their formative years. Why in the world wouldn't somebody look at that? Why wouldn't the lawyer look at the records of the prior violent felonies? Why wouldn't the lawyer talk to all of the siblings? I mean, you can't have reasonable strategic decisions unless you have an investigation. And I think what Justice Lewis asked you to do is focus now on lack of prejudice, because I think that's a harder case for Mr. Hennis. But and that's what the question was. So not that he made a reasonable strategic decision, but he just didn't do the investigation.
Well, if you jump straight to the lack of prejudice on the absence of the information about the Oakley Training School, and remember, the information about the Oakley Training School came about when CCR retained Professor Bell to do essentially a sociological study, like a mitigation, I guess, collection. Say, go find out about Oakley. Talk to people that would know about Oakley.
And isn't that something normally? I mean, again, you'd want that to have happened at the original time of the original.
Well, at the time of this case being tried, you have to credit Mr. Alcott's testimony too, which the trial court did credit. He said that did not factor into the case he was presenting. It was remote by 30 years, certainly. With regard to the penalty phase he was presenting, the whoopings that the defendant said that he received were in fact presented through the testimony of Dr. Kremper, both at that original 1990 penalty phase and the 1994 penalty phase, Your Honor. And if you'll just allow me to digress one moment with regard to Jeff Holmes and the instance of the plea. This case was prepared for trial. This was not a change of plea situation at the get-go. They were in the midst of jury selection, and this case had been fully prepared for trial. And in fact, DOC records had been obtained with regard to the prior mental health testimony of the defendant and had been furnished to Dr. Kremper. And so you have a case that has been prepared for trial. And who does Mr. Alcott present in the 1994 case? He presents a clinical psychologist, a neuropsychologist, and contrary to opposing counsel's representation, a medical doctor, a psychiatrist, the testimony of Dr. Ainsworth. Now, Dr. Ainsworth had passed away by this time, so his testimony was read into the record by Dr. D. And so you have 3 mental health experts. You also have a DOC witness, Marianne Hall, to testify with regard to the defendant's crying and being very upset upon learning that Pearl is how the victim is referred to, that Pearl is dead, and he appeared very remorseful. You also have the 2 sisters testify, the 2 family members. You have both Ms. Spearman and Ms. Cason testify as to the fact that and the jury knew that there was the defendant was given moonshine as a child, that he was harshly punished by his mother.
What was the age difference between Mr. Kilgore and his those 2 siblings?
I believe that there was 5 years with Matilda and 2 more. There's a big age span. There were 13 children in the family. Albert Kilgore, who Mr. Alcott has Albert's name in his trial notes, but Albert's name is crossed out. Well, Albert was born, I believe, in 1938. Mr. Kilgore was born in 50, so you have a big age range there. Albert left Mississippi to improve his life. He did not want to stay in Mississippi. He left Mississippi and did not know about the defendant's troubles and his Oakley experience.
Are there some from zero to he's in this facility at Oakley from 12 years old to 15 years old?
That's what Professor Bell testifies, that he says it looks like it was from 1962 to 1965. And so he would have been 12 to 15 when he was given a furlough at the holidays at Christmas. He came to Lakeland, where his family had relocated, and he did not go back to Oakley. And so you have then after that, and Professor Bell, we've got double, triple hearsay from Professor Bell. Certainly, he did what CCR asked him to do, and he talked to family members, and none of them had been at Oakley. He tried to talk to staff members who had been at Oakley, and were getting conflict. And Oakley, by the way, is still in operation. He would get conflicting reports. And then you have Charlie Thompson. Now, Charlie Thompson, also former death row inmate, was also at Oakley at the same time. He was actually there before Mr. Kilgore, and he would talk about the fact that there was harsh punishment. So he said, okay, well, what's the harsh punishment? He goes, oh, you get whooped if you ran away or if you did something bad. So Mr. Thompson said, well, I didn't run away. I didn't want to get whooped. And he said, well, did you know of Mr. Kilgore getting called to the shop? And that's where the whoopings would be inflicted. And he said, yes. He said, okay, well, how many times? He said, I think 3. So you have over the course of his incarceration, you have now in post-conviction Mr. Thompson's testimony that during that 3-year period he knew of 3 whoopings that Mr. Kilgore had while at Oakley for not following the rules or for running away or for disobeying, and he said that it was a harsh punishment situation. And defense counsel knew that Mr. Kilgore had been in a reform school, and he viewed it as remote and not related to the case that he was presenting. So and the case he was presenting included a focus. Excuse me.
You keep saying that, and is that you're relying on?
I'm relying. Oh, I'm sorry. Hang on.
The diabetic condition, the alcoholism. Is that what the experts were saying is the key to this mental issue that we need to present? Is that what this case is about? That's
much of it, Your Honor. He was focusing on the limited intelligence of the defendant and showing that it was, he used the term mental retardation at the time of the penalty phase, and he used it as a term that the layman would understand, that this man's condition is deteriorating. He's in chronic diabetic stress, and also was asked about that in post-conviction and said, yes, if Mr. Kilgore were living out on the street, he might not have survived because he has been, he has had now 1 leg amputated, but his blood sugar levels are closely monitored. But through the testimony, you had testimony about suffering a head injury, the defendant suffering it, and this is at the 94 penalty phase, Your Honor, suffering a head injury, being severely punished, deprivation, growing up in rural Mississippi, very poor family, not enough to eat. Mr. Kilgore would cry because he didn't have enough to eat. And so you had this humanizing testimony presented from his family, and you had the expert testimony.
I was trying to find out again but these siblings were several years younger than he was. So in the evidentiary hearing, were there any siblings presented that really had the best view of what that childhood was, or do we not have that situation?
Well, you do have some of the brothers who are also incarcerated. You have Jimmy Dean Kilgore testified, and the gist of his testimony was that he was not at Oakley, but knew that his brother had trouble, knew that his brother had been complained about getting whoopings, and that their mother had also been, that she loved them, but drank to excess, would give them moonshine, and would whip them also very hard, but did it spare the rod, spoil the child, I think, as Professor Bell said it. So the gist of that testimony reinforces what was presented by the sisters in 94. The older sister, Matilda, who testified that Dean would get the worst of the punishment from his mother. And so the jury knew that there was a poor childhood, many children in the family, deprivation, suffering at an early age, that he had in fact suffered whoopings, and the mental health experts knew it too. And they focused on the statutory mental health mitigators, which the trial court found, and the defense counsel argued that this was not a case deserving of the death penalty because in his view, and as he expressed it to the jury, Mr. Kilgore did not have the coping skills. He did not have the benefit that other most citizens sitting on that jury would have had. So he certainly, and he made a very significant appeal for mercy. And with respect to the 1978 conviction, Your Honor, and the testimony of Barbara Jackson, well, the state in its opening argument had said that Barbara Jackson at one time had been boyfriend and girlfriend with Kilgore. In post-conviction, one of the defendant's brothers said essentially that, Barbara Jackson was taking advantage of him and would sleep with anybody for money and comments like that. But the bottom line was Ms. Jackson in 1978 was in her home. Her children were asleep. There's something going on outside. Her common-law husband, Thomas Woods, throws open the front door, fires a warning shot, and actually Detective Keel in his version, his explanation of that 78 offense talks about that. A warning shot is fired outside from the front door, in through the back door, glass is breaking, and in comes Dean Kilgore. So he shoots and kills Thomas Woods and then threatens Barbara Jackson to harm everybody in the house, to kill everybody, and she goes with him and ends up staying overnight. He takes her to an orange grove overnight, and she is released the next morning. So Mr. Alcott in his argument says that this man cannot control, does not have the coping skills to manage heartache. And he was on a roller coaster with Barbara Jackson, and he was on a roller coaster with Pearl. And the jury had a full and fair picture of Mr. Kilgore. The information that has been emphasized in post-conviction with regard to Oakley Training School, again, the trial was not an indictment of Oakley Training School, other than it was a juvenile facility where harsh punishment was inflicted, where in 1977 there was a 1983 action where Oakley, the officials for the state were not criticized, but were told that the judge clearly emphasized that they understood that it was budget constraints, but it needed to come into line with respect to providing the children adequate health care, adequate educational facilities, and adequate facilities for giving them an opportunity for rehabilitation. And remember, after this 1965, after the defendant is out of Oakley, between 1967 and 1970, he gets in trouble again in New York. In 1970, he also gets in trouble in Florida, and he is using a gun. He has aggravated assault charge. Actually, Barbara Jackson was one of the victims in that case as well. He goes into a bar looking for Barbara. He starts shooting. It happened to be a package store, liquor lounge in Lakeland, and a police officer comes to the side. He's going through the going up to the side door at the lounge. Door flies open. Out comes Mr. Kilgore. He's got a handgun, and he raises it and points it at the officer. Mr. Kilgore ends up going back inside, takes Barbara hostage in the bathroom, and eventually he does surrender and give himself up. So from 1970 until 1977, he's incarcerated on multiple violent felony offenses. He is then incarcerated again in 1978 for the murder of Thomas Woods and the kidnapping offense. So it is true that the bulk of his adult life has spent incarcerated. It is also true that he is a man of violence, and he is a man that resorts to violence.
But
and
I guess that's what they're saying is the history of violence was coming out.
Well, if it's attributable to three whoopings, Your Honor, I'm sorry. Yes, Your Honor. I apologize. I certainly didn't mean to.
The history of violence is coming out in a substantial way. The only way out on this is to look at this childhood and what happened from 0 to 18 that might have
formed who he was to give a chance of it. Now, you say that's what they did. Mr. Hennis is saying it wasn't really very thorough. That's what we have to weigh. But isn't that what we've got to focus on? Yes, he was a violent man. The issue was, did this stem from terrible childhood trauma and abuse, neglect, whatever?
Your Honor, I would ask the court to pay close attention to Charlie Thompson's testimony in post-conviction with regard to the circumstances at Oakley. Mr. Thompson said that they would also play basketball, they would shoot marbles, they would go to class in the morning, in the afternoon that they would work in the fields, doing farm work. Before the defendant went to Oakley, he was in school when they could afford it, when the opportunity presented itself. That's from his sister's testimony at the 1994 penalty phase. She said the children did in fact help in the fields. You also have a brother, Elbert, who left Mississippi and has been law-abiding. So it is not a recipe, certainly, for that this man is going to become a killer. What you have is testimony that he was punished as a child. On 3 instances, he was taken and he was whooped, according to Mr. Charlie.
On that point about these whippings, I mean, that's obviously that is what it is. But there was testimony about frequent beatings that the defendant received as a juvenile in the reform school, offered in the penalty phase. That's reflected in the trial court's order. So
it's true.
The detail on that does not seem to be that different than what is reflected in the trial court, in the sentencing order.
The trial court was made aware of it, Your Honor. They were not made aware, admittedly, of the details about Oakley Training School. And again, this was not an indictment of Oakley Training School. This was this particular defendant's background and this defendant's history and this defendant's actions. Thank you, Your Honor. If there are no further questions. And Justice Perianti, I apologize if I cut you off when you answered a question. I certainly did not in any way intend to be disrespectful.
Thank you for that statement. Thank you.
I do apologize to the court. I didn't mean any misrepresentation about Crimper. I was thinking that it was Crimper rather than Ainsworth that was read into the record. But on that point, from Crimper's testimony, I think it's important to recognize that the judge didn't find Crimper credible as to his testimony about the presence of mental and emotional disturbance on the day of the crime. Crimper testifies specifically that Mr. Kilgore has limited ability to think about how to solve problems, come up with solutions. It wasn't just something that happened that day or the day before. This was something that was escalating. The question by Alcott is, just so I'm clear then, is it your opinion that at the time we're talking about that he was under the influence of mental or emotional disturbance on that day? And Crimper says, yes. That's not reflected in the court's order. He completely disregards that testimony by Crimper and yet relies on Crimper for the second mental health mitigator. That doesn't make any sense to me. If there are any other questions, I'll be glad to try and address them. I've got 19 seconds left,
No,
I think.
you actually are over by
I'm
20
over, okay.
seconds. Okay, thank you.
Thank you,
We'll
members
take
of the court.
Case under advisement. The court will be in recess till 9 o'clock tomorrow morning.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.